For listing a motion, Lordship, very urgent matter, Lordship, tomorrow or get approval, Lordship.
What is the urgency?
Urgency is that, Lordship, in spite of dishonorable court's order, the registered cooperative society Lordship effort to rebate the matter to the joint register, Lordship, and fixing the date for hearing on 18th, Lordship. In spite of clear order from this honorable court to appeal to be disposed by the registered, Lordship, for which I pray, Lordship,
Okay.
tomorrow possible.
18th, Friday? Friday.
May I please, Lordship, my lord, in item number 33, my lord, further 2 weeks, my lord, may be granted for filing, my lord, objection. Since, my lord, for last 2 weeks, I had some medical issue, my lord, so I could not file, my lord. So, my lord, 2 weeks time may be granted.
And for the applicant, normally I do not oppose, but there's not urgency, my objections may be recorded, I leave it out to law. And date may be fixed.
Okay, let it be reached.
Next week.
Let it be reached. Will the case be reached?
May I please, the Lordship? Lordship, like to mention item number 20, Lordship.
Item number?
20, Lordship.
Okay.
May I kindly be adjourned for the day, Lordship. We have taken consent of other side.
Okay, on the prayer of Miss
S.R. Majar Bhuya.
S.R.
Majar Bhuya.
Learned
Get-
counsel for the petitioner, leaves the case on so and so. Next it. Next please.
0508.
Yes.
May it please your lordship, with the consent of the other side, I beg to mention item number 24, lordship.
Consent to likhi dibo. Item number?
24, lordship.
Yes.
I am on behalf of the respondent, lordship. We have filed our wakalat nama and we will file our affidavit in opposition. So kindly date may be fixed, lordship. I am on behalf of Mr. A. Biswas, lordship.
Okay, who is for the petitioner?
Your Lordship, I'm on behalf of my senior, Mr.
Oh.
A. Nursery.
Miss
F. Nag.
Learned counsel for the petitioner is present. Mr.
P.K. Basu on behalf of A.
P.K.
Biswas.
Basu, learned counsel on behalf of Mr. A. Biswas, learned counsel for the respondent number 528 as sought for and is granted. How much time you need?
Lordship, 2 weeks, lordship.
2 weeks time to file counter affidavit on behalf of the said respondents as the prayer is allowed to release the case after 2 weeks and a date to be fixed by the office.
Obliged.
May I please, my lord? With the consent of the petitioner, I beg to mention item number 13 and 14, my lord.
13 and 14. Yes.
Kevin Pathak has some difficulty with them.
Hmm?
Mr. Pathak has some difficulty today, my lord.
Okay.
Hey, Mike, to the
Okay. Mr. P.K. Bora, learned counsel for the petitioner is present. A separate order, same date. Mr. D. Das, learned standing counsel, APDC, has submitted that Mr. K.P. Pathak, learned standing counsel, APDC, who is to make submission. This case has some personal difficulty today and has thus paid for listing of the case on another date post op. As sought for and agreed to by the learned counsel for the parties, release the case on so and so.
7th August.
Interim order is there. The interim order passed earlier. Will continue till the next date of listing. Same order in 14.
0708.
Lordship, I beg to mention item 28. Lordship, herein we have submitted an adjournment note, your Lordship, and I'm
Okay.
appearing on behalf of Mr. N.R. Surana, who appears for the respondent number 2, Lordship. So, Lordship, he has some difficulty today, we
Prayer is made on behalf of the respondent number 2 for adjournment of the case by
Lordship,
what time?
Lordship, 2 weeks.
For 2 weeks. A mention memo to that effect has also been circulated yesterday. So, in the overview of the matter, the case stands adjourned for 2 weeks.
Lordship,
Let the case be listed after 2 weeks.
There is an interim order in favor of the petitioners.
Okay, then release the case on so and so. The interim order passed shall continue till the next published.
Much obliged.
7th August. 0708.
Or পিছত দি দিব। পিছত দিব।
May I please, your Lordship? With the consent of the other side, I beg to mention item number 21. Lordship, the subject matter is pending before the apex court, Lordship. So it may be taken.
What kind of
The constitutional validity of section 16(4) of the CGST Act is under challenge before the apex court, Lordship.
Okay. Who is the petitioner?
Petitioner, I've taken the consent, Lordship.
Okay, Mr. K. Jain, learned counsel on behalf of Mr. S.C. Kyle and its special Senior Counsel and Special Counsel CGST has sought for an adjournment of case for 4 weeks on the ground that the issue involved in the writ petition is pending before the Honorable Supreme Court. Full stop. It is submitted that the constitutional validity of section 16
16(4).
within bracket 4 of the CGST Act 2017 is the issue involved. Full stop. As the praise made with the consent of the land council for the petitioner, lays the case after 4 weeks on date to fix by the office.
Much obliged.
Time to file step, to
12?
take steps. Item number 12.
Make a mention when the case reaches.
To mention item number 23, my lord. Kindly 3 weeks time may be granted for filing our affidavit, lordship.
Affidavit? Okay, Mr. S.K. Saha, learned counsel for the petitioner has sought for and is granted 3 weeks time to file an affidavit in reply to the affidavit in opposition filed by the respondent CGST authorities
My lord.
Hmm?
Income tax, my
or
lord.
income tax authorities. GST, it is shown GST. Okay. It is submitted that consent has been taken from the landed council for the respondents to make the prayer. Raise the case accordingly. The prayer is allowed, raise the case accordingly. As sought for granted, raise the case accordingly after 3 weeks on a date to be fixed by the office.
Interim may kindly be
The
continued.
interim order, if any, past idea shall continue till the next date of listing.
Obliged. Please, your lordship. For listing our repetition on Monday, lordship. The-
Admission,
Monday.
admission. Give it to the court master.
May I please, your lordship, may I pray for adjourning item number 34, lordship? Because the respondents have filed an affidavit in opposition today at 10:29 AM.
34.
Yes, I would like to file my reply. The affidavit. of
Okay,
opposition.
Mr. R. Bora, learned counsel for the petitioner have sought for and is granted. How much time?
2 weeks would be sufficient.
2 weeks time to file an affidavit in reply to the affidavit in opposition filed by the
Respondents,
all respondents.
all respondents. The water.
Filed by the
resource
respondents,
authorities.
filed by the state respondents. A list the case after 2 weeks on a
2
date
weeks.
to be fixed by the office.
May
Next,
I pray for a date, lordship?
Lordship, I'm paying for listing of an item for motion, your lordship, on Friday.
I'm praying for listening to matters lordship in admission column.
give it to the court master.
Daily list for motion, item 1.
I have filed a amended clause. Title. I am pleading.
Amendment was.
Art with DD
Before
Roy,
filing it,
learned counsel for the
I am
petitioner.
pleading collector.
Petitioners. Mr. Andas, learned junior government advocate, Assam, for the respondent number 1,
1,
2, and 4.
4.
Full stop. The petitioners have stated that they filed a claim application before the Motor Accident Claims Tribunal, Kamrup, Gauhati. Under section, under the provisions of the Motor Vehicles Act, 1988 seeking compensation for the date of one Ites Taluga on 59/2008 in a motor vehicular accident. Post of. The claim application which was registered as MSC case number 2554/2019. Was disposed of by an award dated 29/6/2013, awarding a compensation of rupees 5,40,000 with interest at 6% per annum from the date of filing of the claim application, i.e. 23/12/2009 till payment. Post of. Para, the petitioners have stated that the disease was the husband of the petitioner number 1 and the father of the petition number 2 and 3. Post of. The offending vehicle belongs to the respondent number 2. Post of. After the award dated 29/6/2013, comma, the motor accident claims driver, comma, due to non-deposit of the compensation amount, comma, issued a recovery certificate. And on the basis of the said recovery certificate, comma, a legal proceeding. Bakija proceeding initiated. Bakija?
Yes, but not registered.
Huh?
They have not registered the case, my lord. As per them, we should giving them the name of the person, my lord.
Recovery certificate issued for recovery of the compensation amount. Post of. It is the case of the petitioners that despite issuance of a recovery certificate, no action has been taken by the respondent number 4 to initiate, to register any Bakija proceeding for recovery of the compensation amount. Hence the petition issue notice returnable on so and so. As Mr. Das. 1, 2, and 4. No. Of formal notice. Extra copies. 2 working days. Steps upon respondent number 3. by speed post reading to.
17th August.
Respondent number 3. Stack of beer. Name of the respondent number
File an
3.
application for that.
1708. Item 2.
May it please your lordship. Lordship, this is also a Zamindari estate case from the same Coach Begila Zamindari estate, your lordship.
Okay, get the order corrected. Give it. Page 30, page 30 order. Get the order is page 30, correct for it.
Obliged, your lordship.
I pass similar order.
Lordship.
Get the order corrected.
Lordship.
Mr. Hyde,
I.S. Mother.
I.S. Major Bhuya, and aforesaid revenue, 1, and thus 2 and 3. A page 30 order, correction for it, total order due to page 30.
Item 3.
Same.
Your lordship.
Respondents are same.
Same line.
Correct it.
Lordship.
Item number 4.
My lord, this day I pray for notice, my lord, because on earlier day, place one instruction, my lord. That was instruction is not correct, my lord. Then I have a copy, my lord. We have been served.
Who is the standing counsel? Bhima Asam. Let him come. Let him come.
Item 5.
Lordship, pass over the matter for time being.
Item number 6.
My senior say never that.
Kindly pass over the matter for the time.
Item 7.
Lordship, my senior is on legs in another court. Kindly pass over the matter for time being.
Number 8.
May I please, my lord?
Yes.
My lord, this matter relates to land acquisition proceeding, my lord. The
Petitioner is the owner of a land. It is acquired under what act? Which act? Huh? National Highway Act. National Highway Act, there must be then notifications published in Gazette. What are those?
notification the petitioner could not obtain, my lord.
Lordship, in this case, Lordship, he has admittedly stated that he has received the amount of rupees 20 lakhs, Lordship. If amount is not sufficient, Lordship, he has to approach the arbitrator, Lordship, under section 3G5 of the Act.
But we are not having any document regarding acquisition process.
Yes.
Neither 3A, neither 3D. The repetition is very vague.
3D notification he has just
Only two
sent me
representation
yesterday.
and one shall be, Lordship.
My lord, 3D notification he has sent me just yesterday, my lord. I will file one additional affidavit, my lord.
Finally, then only we can find out something. Otherwise it will be difficult
Yes, my lord.
to make a fishing inquiry. Okay, Mr. A.K. Gupta, learned counsel for the petitioner. Mr. R.K. Talukdar, learned standing counsel NHI DCL for the respondent number 1, 4.
And 4, my lord.
Mr. H. Sharma.
PN 5.
Aforesaid, learned standing counsel Revenue Department for the respondent number 2.
Respondents on behalf of Venus.
Huh?
On behalf of Venus, respondent number 6.
Mr. H. Sharma, learned traditional senior government advocate for the
Three and five.
3 and 5. And Miss
D. Sharma.
D. Sharma on behalf of learned counsel, on behalf of Mr. D. Nath, learned standing counsel PWD for the respondent number 6 are present. Also, Mr. Gupta has sought for listing of the case after a week in order to file an additional affidavit to bring on record the concerned notification issued under the provisions of the National Highways Act 1956. List the case in the motion column after filing of the additional affidavit,
Can it be on Monday, my lord?
the leave for which he is granted. Is a case for Monday. Monday is the VCS of India.
What is it? 22nd July. Item number 9.
May I please, Your Honor?
Yes.
Lordship, a matter of attempting to land grab has been taken up by the central officer and the district commissioner and the CDC. And based upon that, the interim notice was issued. That Lordship will find a case number 63, my annex of 14.
63.
63. May I read out my
Whoever the petitioners there, petitioners have submitted.
petitioners, my lord, the name Lordship will find at page number 59. So these are the persons without disclosing their address, parentage, only by providing the mobile number. So they have filed this application.
What is LRA? Land Record Assistant.
Yes. This Mundal and other stuff, revenue control group. So here, Lordship, there is
It is
no
very
provision of law is quoted under which provision of law this order of attachment is passed. No date, nothing is fixed for appearance and to file any written objection or written statements. No civil, nothing, my lord. Land belongs to us, although it is recorded as a ceiling surgery land.
No, it is government DAG number. It is-
Yes, my lord, yes. But my lord,
Once it is government DAG number, it is belongs to the government.
yes, my lord. But my lord may be pleased to peruse.
Now let us read third paragraph. What does it say?
Whereas as per field verification, it is found that the petitioners are in possession of government DAG number 1245 of village Jutikusi under Beltola Moja by constructing boulder wall and brick walls in part of the concerned DAG, and only out of all the petitioners, only Projit Gogoi, Deepak Gogoi, both son of late Pawan Gogoi and Lal Babu Paswan, son of late Ganga Paswan, has possession over the plot of land. Where from they come?
And next paragraph.
Whereas it is seen that the opposite party are allegedly grabbing the land by constructing tin wall and has tried to change the character.
Who
of
is the
the-
opposite party?
So definitely we are the opposite party, because in the earlier proceeding also same application was filed stating the same facts which was disposed of, my lord. In that proceeding, we are the opposite party, the petitioners. That lordship,
Is 1245 is government land or not?
1245, my lord, there is a history.
No, no,
That-
as on date.
as on that it is a government land. It is recorded as a government land. The history lordship will find at our annexer 2, page number
No,
30.
as on that character of the land is government land.
Yes. It is designated as a government land.
What is your claim on that?
My claim, lordship will find it.
Tell me without going into records.
Page number 37, my lord. What happened? It was acquired under the ceiling. So a case was filed in the year 1976. Ceiling case number 225/76. So we submitted the return, all our lands, and in that proceeding, which was disposed by order dated 29/12/1990.
Where is the order?
Lordship, there is a return. That lordship will find it page number 37, annexer 2. It is submitted by the district collector of at that time. Page number 38, para 9. So plot numbers of lands selected for retention by the person, outlands not coming under scope of X exemption under section 2. Here 256, the old DAG number is there, which has now become 1245.
256 has come under this
1245 now.
ceiling case.
No, it has been exempted. So land selected for retention by the person. Our predecessor was that person. So what happened, my lord? This is prepared by the vernacular form. My lord, it starts from page number 42. Although it is spared, it is submitted by the then additional deputy commissioner, Gauhati, in 1990. And another DAG is also involved in the whole matter. That is the new DAG number 1087. And this 1087, my lord.
So this 256, if it is spared from the Ceiling Act,
Yes.
when it became government land?
So prior to 1976, before we filed that ceiling case, my lord, it was acquired under the Ceiling Act. But as
You said in 1990, DAG number 256 has been spared.
Yes.
Has been spared,
Yes, ma'am.
right? Exempted.
Exam.
Meaning thereby it remains as Patta land.
It is a Patta land.
Patta land. Then how this transformation took place and when this transformation took place from government Patta land to private land, government land. DAG number 1245.
My lord, what happens? In between, in the year 1993, these 11 petitioners, which I have already shown, they claim that they have purchased the land from DAG number 256 and 263 from the power of attorney of our predecessor. So, if it is a Sarkari land, how could the DC can grant
If
the
you
NOC?
say, if you have said that 256 has been spared,
Yes.
if it has been spared, it remains to be transacted,
Yes.
right? It was open
Open.
for transfer of the land,
Yes.
right?
Yes.
Then what happened thereafter?
My lord.
If it is out of the purview of the ceiling case,
Yes.
256,
Yes.
what happened thereafter?
But still, as on date also, it becomes a Sarkari.
That is why I am asking. If
Thereafter, my lord-
1990, DAG number 256 has been spared
Yes.
and it is out of the purview of the ceiling case,
Yes.
so it remains a Patta land.
Yes, it is a Patta land now.
It remains a Patta land in 1990. Now, as on date, how it became government DAG? 1245.
That is wrong to them, my lord.
Oh, that is, you are throwing the ball to them.
Yes, my lord. Because why, my lord?
Okay, by filing
Along
this
with-
petition, you are throwing the ball to them.
Along with 256, 263 was also.
No, we are not concerned with 256, 65.
My lord.
If your predecessor
Yes.
was the owner
Yes.
of DAG number 256,
Yes.
right?
Yes.
And it was under the purview of a ceiling case. But at the end of it, in 1990, you say it was paired. So it is out of the purview of the sealing proceeding, right? So it remains
A patta land.
patta land.
Yes.
So if it remains a patta land in 1990, and you say that DAG number 256 has become 1245 subsequently, how this transformation from patta land to government land took place?
My lord, that I have also pleaded you, that after 1990, this land was never acquired by government under any act.
No, there must be some record in the land records. Maybe due to the non-deposit of land revenue.
No, my lord. Because why? This
No, no. First,
263.
I have to satisfy myself that why should I issue notice?
Yes. My lord, why?
It cannot automatically become
Yes.
government land. Hidden some ghost will not act.
Yes.
Only man will act.
Yes, my lord.
And man means land revenue staff will act.
Yes.
Or revenue administration will act.
Yes.
So how this private land become government land? And who are you? And you said that on the basis of power of attorney,
Yes.
somebody purchased those lands, claimed to have purchased those,
Yes.
right? Those applicants. And at that time, where were you? You were 64 years and 59 years old.
Yes.
Where were you? Where
We are the sons of
where in the where were you in the scenario?
My lord, we are the sons of late Dijendranath Bora.
Okay.
He was the owner.
Okay.
After his death,
So 1990 and 2026, 36 years.
that case was pursued by our father. 1990 case. This 76 case.
Right. 1990 it ended.
Yes, it ends.
It ends. And when did your father die?
Father, he died on 19/7/1995.
1995.
Yes.
So when this land became government land?
Again, when it becomes a government land, my lord, there is no any such record. Because after 1993, why, my lord, the another adjacent ducts, which are mentioned in this Annexure 2, my lord, this 263.
An allegation of government land, land grabbing does not sustain against the government, revenue administration.
Yes.
Land grabbing is a concept against private persons. Otherwise,
Yes.
conceptually,
Yes.
land grabbing is
Between
related to
individuals.
private persons.
Yes, two individuals.
But this is a order of an authority, circle officer.
What happened, my lord?
Miss Mormon, have you understood the case? I have not understood the case.
Clearly. Not clearly.
Huh?
Not clearly.
May I know, my lord, particularly which point?
No, firstly, when this, in 1990, a plot of land was patta land,
Yes.
right? Because it
again
went out of the purview of the, according to you, I have not read this because I could not read, I have not understood. How in 2026, the same plot of land became government land? It is for you to say you are saying 1245. Earlier DAG number was 256.
256. Kindly see, my lord, the 263 also. Now, these individuals who have preferred their application, they have got mutation in 263, which is new 1087.
No, first you tell me why it became government land. To stake a claim over DAG number 256, you have to apprise the court how it became government land.
My lord, my pleading is that after 1990, this land was never acquired by the government.
No, it is
And-
not a question of acquisition.
Yes.
If acquisition is okay, there must be proceeding for that.
Yes, my lord.
And there must be compensation paid.
Yes, yes.
But otherwise, a private land, periodic pata land cannot be transformed to government land.
Yes.
There must be something
Some reasons.
that non-deposit of revenue
Yes.
entitles the government to make it a government land.
Yes.
But if you don't disclose this, how can we proceed further?
My lord, what happened?
Madam, you also go through. We'll take up on Friday. Mr. Bora.
My lord, in between, in the year 2024, I have also preferred an application. The lordship will find it annexure 3.
Okay, let us see. Page 45. I have just flipped the page. Regarding restoration of patta.
Hmm.
This is the subject.
Yes.
So where is your application?
My application, the lordship will find it annexure 3.
But your page 43 application.
Yes. Vernacular one,
No, page
44.
43, vernacular.
vernacular 44. English one, page 43, translated one.
But there you have admitted that sealing hoy.
Yes.
Sealing hoy.
Yes, on record it is sealing, my lord. Although it is.
No, you were all along, you have been submitting that it was not brought under the Sealing Act.
Yes, as per the statement that is prepared by the then additional deputy commissioner. 256, 263.
So you are
some things are
making contradictory submission. In your application, you say that this land, you have not mentioned about DAG number also in your application. Page 43. What is this? Neither in page 45.
Because there is.
Where in your application, where any of your application that DAG number 46, 256?
No, my lord, here reference is made to the case number 225/76.
Oh.
In terms of this.
See, Mr. Bora.
Yes, sir.
See, Mr. Bora returned let us go to the return.
Page 42.
Page 42. So many DAG numbers are there.
So that matter. In that 256, column 9.
That is 256 is one of the DAG numbers.
In
Now
column
see
number
his
9.
application at page 43.
That is right.
Huh?
I agree. That
So,
particularly this DAG number is not mentioned.
you want to fish out take out a fish out of the ocean. So many DAG numbers.
Yes.
Page 43.
Column 9, final.
And you said there that this has been brought under Sealing Act. Only you had possession according to you.
Yes, we had the position.
But
Because-
you have. Mr. Aforesaid, you go through it. The provisions. Mr. Bora. How it is transferred to government land. I have not been able to satisfy myself.
But my stand
And
is.
no, we do not go for fishing inquiry,
Yes, ma'am.
roving inquiry. No. Unless you satisfy me, how it became government.
On the basis of this petition, cannot be asserted.
No,
Something.
Absolutely not.
Has to be.
Absolutely not.
He has to bring on.
Let him take instructions.
No.
my lord.
Why? I will not permit. I have said, Mr. Bora, I will not go for fishing inquiry.
My lord, but my stand is that.
Your stand may be there. You take the stand. I am outrightly dismissing it.
So sometime may be granted then, my lord. I'll take instructions.
This is not the way to file a petition without, for 36 years, you have been doing nothing.
Yes.
256, you say your statement is contradictory. Your application is very vague,
Yes, that application is made.
absolutely vague, nothing.
Only reference to the case number is given.
There are 20, 30 drug numbers.
Yes, my lord.
I'm not. It is not possible for me to understand.
My lord, then some time may be granted.
And it is not that you are not aware of. You are 64 years and 59 years old. It is not that you do not know. See the age of the petitioners. I could have understood that 20, 25 years. All along you were there.
Yes.
When 1990 orders were passed,
Yes,
you were there.
We are there. All the minors maybe.
Not minors in 1990.
Yes.
Don't take that plea. On the request of Mr. B. Bora, learned counsel for the petitioner, raise the case on next week. Ms. Gorman and Mr. Aforesaid, you go through the application.
2407, 24 July. Item 10.
Mr. Mishra,
My lord, cancellation of GST issues, my lord.
2024.
Yes, my lord.
Say, my lord, limitation will come, my lord. The series is there, my lord. Let it come along with the similar case, my lord, on that point.
Because
90 days.
90 days
for
revocation, it will be difficult. Now, Mr. Gogoi,
My lord.
suppose his registration remain cancelled.
No.
What is the option for it?
He will have to, my lord, re-register himself, my lord, now. In that
What is the
case, my lord,
provision?
fresh registration.
Ah.
Yes, there is a provision, my lord. Only he will have to, my lord, clear his dues, my lord. That's like
Give a write-up.
lordship.
Give a write-up.
Yes, that we can, my lord. Yes.
Give a write-up. If it is possible
Hmm.
for fresh registration, because limitation issue comes.
My lord.
My lord.
And there is nothing, your revocation was not within time.
No, my lord.
He will lose
No
his
appeal
ITC, my
preferred.
lord. That is his only concern, my lord. Regarding ITC, that is the only concern of most of the petitioners, my lord. If they apply afresh, that ITC goes. That's the concern. Otherwise, my lord.
No, but he has to suffer.
Yes,
Now the SSC has to suffer.
my lord.
That is not our concern. We have to abide by the law. Now, which provision?
It's there, right?
If there are instructions, circulars, notifications,
My lord.
give a write-up.
Lordship, I would furnish the written instruction.
And what is the consequence to be suffered
My
by
lord.
the SSC in case of press registration? Because here it is 7/10/2024, so cause 4/12/2024. Then a revocation application is hopelessly beyond time. Huh? No appeal. Everything is foreclosed.
Yes, my lord.
And it is not that so cause notice is silent or the order of cancellation is silent. At least that is there.
Is there.
See, there is page 16.
My lord.
Remarks. Something is there.
Only provision of law is mentioned, my lord. The rule
Huh.
21 and then that much only, nothing else, my lord. And my lord,
And it is not your case that you did not receive this so cause notice.
it's in the portal, my lord. But my thing is that, my lord, if it's revived, my lord, it will never prejudge the government.
No,
Because,
no. Question is also
my lord, law,
because there are many collateral issues.
my lord,
Many collateral issues.
my lord.
Persons are filing 226 application against order under 73, 74. These are correlated.
My lord.
Mr. Gogoi,
My lord.
give a write-up regarding fresh registration, whether there is any prohibition or subject to what compliance.
Lordship. After cancellation. After cancellation
After
for re-registration.
You also, which provision, give a write-up.
My lord.
Otherwise, you will be facing difficulties.
Right.
Otherwise, I can outrightly dismiss this.
Yes, it's true, my lord. They say delay
Outrightly dismiss it.
is there. I am admitting, my lord. I am not disputing at all, my lord.
Hard will issue notice, same day video, very day.
There is a
21st
judgment of
July.
coordinate bench, my lord, that has dealt with this issue regarding fresh registration all, my lord. If lordship permits, I can place it on Friday or Monday. This limitation issues, everything was dealt with. And my lord, question that argument of fresh registration was also argued, my lord. So that view of the court was that, my lord, either it will revive or he will take new registration. Process is same. The court says it's better to revive it after payment of all taxes, my lord. Then court came to an opinion, better to revive it after making payment of all taxes and dues, my lord. That was that argument was placed, even ultimate remedy argument was also placed, my lord. Everything was considered.
Whether it is legally tenable.
Yes, because in view of the Honorable Supreme Court order. That was not placed well when that order was passed.
Now, if it is listed also, the same view as of this court is will be of the view of the other court and bench.
What's my issue notice?
The view will not change
That they should.
now.
Yes, sir. What's my issue notice? In the meantime, we'll find out something more.
See the consequence, Mr. Gogoi.
Yes,
Because these kind of petitions are
yes, now flooded.
every day flooded.
Yes,
So, whether it is possible for fresh registration.
flooded.
Secondly, if fresh registration is permitted, under what provision?
Consequence and the provision.
And plus the consequence to the SSC.
Man.
There may be some prejudicial effect also.
Lots.
We'll examine that.
Lots of.
Mr. Mishra, you also do
Man.
it. Heard Mr. R.S. Mishra, and
Legal
for the
inspection
petition,
will
and
be
Mr. B. Gogoi. Standing Counsel, Finance and Taxation Department, Government of Assam, for all the honest the petitioner has approached this court by the instant petition agreed by an order of cancellation of registration on an order dated 4/12/2024, whereby the petitioners registration under the Central Goods and Services Tax Act 2017 has been cancelled. Issue notice returnable as all the respondents are represented. And considering the issue involved, the notice is made returnable on
Yes.
5 years.
Take it up, other results. Other cases are will be listed on 3rd of August.
We'll see
Yes, sir. 3-4 cases are there.
as extra copies. Pure. But I will not record that.
Yes.
You give the write-up.
Yes, yes, I will.
Item number 11.
May I please, your Lordship. Lordship, we are the owner of the land of 1 bigha 2 kata, and by order dated 21/3/2023, our name is mediated. And after that, we have made a representation before the circle office for demarcation of the land, but till now there was no.
Yes, madam.
Lordship, regarding the application made made by the petitioner, Lordship, the application is not made under proper format, Your Lordship. The
Any order, my latest order demarcation.
requisites are not provided, Your Lordship, the requisites are not provided along with the application.
And this is under ATPS. It is manual now.
Yes,
And this application is manual.
manual also,
Let him,
even if it's
file it.
manual also, the annexures are not there with the whatever is
Let it
required.
file under the provisions.
Yes, Your Lord.
Following due procedure.
Yes, Your Lord.
Okay. Heard Mr.
A.S. Chaudhary.
A. Chaudhary, Line Counsel for the petition. Petitioners. N. Bodoloi. Standing Counsel, Revenue Department. And Ms. M. Bormon, Learned Junior Government of Assam for the respondent number 2 and 3. Where are the case of the petitions? Case projected in this petition is that the petitioners are the daughters of one late Ramnath Das, right?
Yes, sir.
Full stop. Ramnath Das, their father, the petitioner's father, Ramnath Das, was the owner of a plot of land measuring 1 bigha. Out of a parcel of land measuring 1 bigha, 2 kathas, 10 lessas, covered by tag number 62 and KP Patna number 447, situated at village.
Village is not given, Roha Revenue Circle, Moza Roha.
If it is not village, how can it
Hariamukh
be?
Revenue Village.
Village Horiamukh, Roha, Moja Roha Revenue Circle, District Nogam, subject land. Full stop. After the death of their father, the subject land stood mutated in favor of the petitioners for by way of inheritance pursuant to a mutation order dated 21/3/2023. Full stop. The petitioners have asserted that they are in continuous peaceful possession of the subject land and are paying land revenue regularly. Full stop. Para. As the subject plot is a part of a parcel of land measuring 1 bigha, 2 katha, 10 lessas under the same bag number and pata number. Is it so? Who is the other owner of 2 katha, 10 lessas?
Yes, the four we together own this.
Hmm?
We four daughter of late Ramnath Das together own this.
No, you say that 1 bigha. Who is the owner of 2 katha, 10 lessa?
Worship may look into page 9.
For demarcation may not do. It is an Azmali patta.
Partition. Maybe partition is required.
It has to be, if it is Azmali patta, you have to seek other service also, not demarcation. Both. Otherwise, it will not. Who is the owner of the remaining 2 katha 10 lessa? Where is the Zamavandi?
Ramamandi in page
Page
11.
starts from page 9, Your Lordship.
Santanu Dev Borua, Pitanu Dev Borua, all those are there. Many are there. Many are there.
Yes, Your Lordship.
So many. What are the petitioner's name?
Rambha
Chandravati, Bhadravati, Prabhavati.
Rambha.
Page 11, Your Lordship.
11. Then Prabhavati. Prabhavati 14. Bhadravati
Chandravati.
13. Chandravati. 11 to 14. Niru Bora. There is Niru Bora. Then Bandit Dev Borua. Then there are 4 others.
Yes, sir.
Aurobindo. There is another family.
ইহঁত কোন হয়? 9, 10, এইকেইটা কোন হয়? সিহঁতৰ পৰা মাটি কিনিছে। সেইবোৰ পৰা নাই তাতে। সিহঁতৰ নামটো কটা নাই যে। Nirupora, Dictaful.
You have to apply for separate patta also along with separate. This will not do. I will not create more difficulties for the revenue authorities.
Other.
You come up with better particular, make an application for separate patta out of that, because patta number is same. Patta number is 447, tag number is 62, and there are many others. So how can it be possible without? Or otherwise make an application, demarcation. It is a further case of the petition that they submitted an application before the response number 3 on 23/3/2026, seeking demarcation of the subject land out of the parcel of land measuring 1 bigha 2 katha 10 lessas covered under tag number 62 and patta number 447. Full stop. As the said application has not been given consideration till date, the petitioner is before this court seeking direction to the respondent authorities, more particularly the respondent number 3, to carry out the demarcation process. Ms. Bordolo and Ms. Borman. Have conjointly have submitted in unison that the petitioner, it is mandatory for the petitioners, for an applicant, to submit any application for demarcation strictly as per the provisions of the Right to Public Services Act 2012 as amended, as demarcation is a notified public service. And in the case in hand, the petitioners have not submitted their application for demarcation as part of prescribed procedure. Paragraph 5 will be done. You file an application under the RTPS, and there is a procedure also, perfect partition with the consent of the co-pattada. Perfect partition can be made. So that is also a notified service. Make both the application.
Oblige.
Thank you. One of my furnitures, that shop was sealed without any notice. This is the case. And I kindly come to page 21.
21.
Page 21.
Yes.
The law, it is dated 30/5/26. And the lawful fine was
both. Now therefore an exercise of the powers in the so and so, you are hereby informed that aforesaid establishment shall be sealed on 1:45 PM on 3/30/5/26 by the municipal board. Same days they have come the notice and they have sealed my shop. Thereafter, my lord, I am given all the papers. That's starting from the notice from Annexa 1. Municipal would register it as renewed. Thereafter, Forest Department, they have issued a notice.
Forest Department.
Yes. Yeah, both by the forest as well as the municipal. Both came together and they sealed this point.
Which one is the forest notice?
Forest notice you always will find. One notice they have given is a general notice file. Page, you always page 23.
Assam Wood-Based Industries Promotion and Development Rules 2022.
Yes.
What is that? Do you have a copy of the rules? Let us have.
That is normally regarding Agar Road, Agar Road, basically. Anyway, even then I have submitted in person notice, I have also submitted, payment was made for registration. Page 25 condition, page 25. In person notice, they have given.
But yeah, wood-based industries. No, it is general wood-based industries, not agarwood.
No,
Whether
that is-
the definition restricts it to agarwood.
No, it was made in keeping in mind of the other Agar business model.
No, but other may be there.
No, it is not mentioned.
Wood-based industry. Let us see wood-based. What is the definition of wood-based industry? Furniture unit.
Yes.
You run a furniture unit.
Yeah, furniture.
Okay, let us see. Furniture unit means
It is secondary wood-based industry. Kimana Silk 32. Page Kimana.
Furniture unit is there, definition.
Yes.
Now,
Second,
whether furniture unit
yes,
has to take registration or not.
that is the question. One
But
registration.
I have not read.
But-
I am asking you.
No, I don't have copy, otherwise, it is second hand, my lord, second base. Secondary wood-based.
industries.
It is part of the mentioned. Kimana Silk.
Definition
Rule 2.
Means, okay, industry means industry which possesses wood. Commercial shops, furniture units.
Yes. We purchase from the timber from the other department.
So your secondary wood-based industrial
Wood-based.
unit.
As per this.
Okay. Now, whether it requires registration.
Now there in terms of the notice dated by the 14/5, page 23.
No, once an act or rules comes and
Yes.
it is notified,
Yes,
then you have to follow it.
we followed.
No requirement of any
Yes,
notice.
yes, right, exactly so.
Now, whether
Then we have applied in terms of that,
no,
we applied for.
apply is different. Apply is subsequent.
But
The
that
act is earlier.
That's true.
So
That's-
where is the
That's true.
where is the requirement for registration?
So requirement, this is not the only thing, madam. They did not say what violation I have done. You will kindly see.
Whether I am asking you a question,
Yes,
whether under these 2022 rules, you are a secondary
furniture.
unit,
Furniture.
secondary
Wood-based furniture
wood-based industrial unit,
industries.
because you are a furniture unit or
Right,
commercial
right.
shop, right?
Right.
Whether it requires registration,
As per this notice, that is required.
where is the provision?
We have taken the provision by the only we got the notice, madam.
No.
Just hold this.
Give me to the, take me to the rules.
That I have not. It is, it must be very.
Yes, Mr. Gogoi.
Yeah.
Lordship, this rules even I'm going through, Lordship.
Oh, you are
No.
going through, so Mr. Chaudhary is going through and you ask me to go through. It is your duty to go through.
There is nothing mentioned specifically, madam. We have seen, especially there is no requirement of registration, madam.
Is it so?
Only.
The rule itself says establishment and regulation.
Regulation.
So
Now.
There must be there.
We have-
I find it contrary to the submission of Mr. Chaudhary.
My lord, I have gone through it. I could not find it there, but I was saying it is not.
Yes, Mr.
Lordship, as per this,
Ahmed,
Chaudhary, he is
Chaudhary.
also Chaudhary.
have you gone through it? There is nothing.
Not specifically mentioned.
but at the 2000 rules, the Assam wood-based industry establishment regulation, section 8, Your Lordship.
Which one?
I
am having a.
2022.
Rules.
This, you might get in this forest manual, Your Lordship. নালাগে আছে। Assam forest manual. Assam wood-based industry, 2000.
Yes,
Industries establishment regulation. At page 102, Your Lordship.
Establishment regulation.
Yes.
Just a minute.
As in,
Okay. Yes. Which rule? Which regulation?
8, Your Lordship. Maintenance of registration submission declaration on that would not be applied, Your Lordship. License and registration maintain registration form 5, 6, and 8.
But Mr. Gogoi,
Lordship.
it does not.
Say about registration, Lordship.
No, it does not say about this commercial shop or
Yes. Does not
furniture unit. Sir, you come both prepared.
But even though, Your
It's
Lordship,
not for me to go through all.
but at
yes,
page
yes.
28, Your Lordship, at page 28, he has been issued a notice.
No, if Mr. Gogoi,
Lordship.
page 28,
28.
page 20 is notice 7, 8, 9, it is for the seizure matter. The sealed
Produce-
on 30th and the seized on 2/7/26. Can they do it?
first page 24. Page 24.
23 was.
No, come to
Yes,
page
yes.
24.
23, original notice.
I generally don't look at translated
Yeah,
copies.
right.
He says, all furniture units should register your furniture unit under this rule.
Yes.
Right.
Right.
So if he cannot, if there is no provision for
We could not find. out.
registration,
Yes.
then this notice is unauthorized. But if there is provision,
Then I am to do it. But you also kindly see, even in that case, we have also applied.
no, that is a different.
Even suppose.
No, that is
I have
subsequent.
shown my,
Subsequent.
I have
Miss-
shown my concern.
You cannot say that, if the registration is compulsory and they have done it, you cannot say that my subsequent application will validate my earlier thing. No, that is, cannot be.
That I cannot say. Then page 28,
Oh, it is there.
page
It
20.
is there, it is there.
This is dated 8/7/26. Can I know date? Can I know find it?
Oh, it is there. Why, Mr. You are saying A.H.M.R. Chaudhary? Saying that there is more provision? Rule 8. All secondary wood-based industries that are covered under these rules, such as furniture units, and so and so, shall obtain registration under these rules. Any person seeking registration under these rules shall make an online application as per Form 9
Form 9.
to the divisional forest officer concerned in online mode through the website or portal. Every application shall be accompanied by a non-refundable fee of ₹2,000.
Yeah, we did it by page 25.
Not subsequent.
That's true. That I am not justifying that one.
So what is the consequence of non-registration? Have you read what is the consequence of non-registration? Oh, I
That
am
will come after
reading
some
it
time, my lord. Let me go to, I go to, after some time, my lord. Let me see.
tomorrow. No, sorry, Friday.
After some time, I.
No. This is not the way Mr. A. Chamber should read to brief your senior. I have to find out. None of you are
We
assisting
have to find out, we have to solve
No,
your
no,
lawsuit.
will not permit.
It is not your lawsuit.
Mr. Sodri Lance, Senior Counsel, estate by H. M. Sodri Learned Counsel for the petition, and Mr. R. R. Gugoi, Learned Counsel, Forest Department for the state respondents, and Mr. N. Das. Learned State Counsel are present as sought for by the Learned Counsel for the parties. This is the case in Friday.
Item 50.
Let him go through,
yes,
so that he can.
No, I will also go through them.
I'm not saying you, but he has to brief you.
That's right. He stayed with that there is no.
No, it is not an exercise to be done in court, reading the entire rules.
Yes, sir.
And you have not annexed the rules also. Please furnish a copy to the court master. Either of you.
Yes, sir.
By today.
I'll do it.
If none of you read, I'll read on Friday.
I'll.
Item 50.
If the act is illegal, it is illegal. But we have to go through the rule.
May I please, your lordship? My lord, the petitioner before my lordships are, my lord, the small scale industries, my lord. And
Petitioners.
my lord, they are small scale industries, my lord, represented by their proprietors, not before my lordships, my lord. My lord, the issue is that, my lord, the petitioners under the scheme of the Assam Small Scale Industries Development Corporation, my lord, allotted a land of the industrial estate area in Sri Bhumi district, my lord, along with the some sheds for the purpose of, my lord, for the establishment of their respective industries, my lord. And responding to the allotment orders, my lord, the lease agreement is also required to be executed, my lord, and accordingly which we did, my lord. And when we are continuing with our, my lord, businesses by constructing the sheds and other parts, my lord, suddenly, my lord, so cause notices had been issued. I beg to draw. My lord,
Just a
may
minute,
I?
just a minute.
My lord.
You are three industries.
Three industries, my lord.
Right.
My lord.
You executed agreement.
My lord. My lord.
Right, with a statutory body. Same agreement or different agreement?
Different agreement.
And thereafter, so-called notice, same notice or different?
No, no, my lord, different notice, different notice.
And replies consolidated or
Separate, my lord.
separate?
Separate, my lord.
Then the cancellation order?
Separate, my lord.
Separate.
Separate.
So how can one industrialist vouch for the other industrialist?
No, my lord, yes, my lord, that the clubbing.
Please address this.
Lord, the clubbing of trees, my lord.
This is.
My lord, my lord. The cause of action.
Absolutely, cause of action is different.
My lord,
And how can one industrialist vouch for other? For example,
my lord, my lord.
Tata vouching for Reliance, swearing the affidavit for Birla and Adani. Is it possible?
That is not possible, my lord.
Scale of revenue is different thing.
We also, my lord,
Three industries, three agreements, three separate so-cause notices,
three cancellations,
three separate individual replies, three separate cancellation orders.
My lord, I can understand.
Rest is yours. I keep it open, maintainably. Next time fate is known.
My lord, only the difficulty, my lord, is that, my lord, I also discussed with my learned colleague, my lord. My lord, the time limit which they have given is very short, my lord. By today, we have to hand it over the, my lord, respective properties to the, my lord.
Phase 99?
My lord.
No, voluntarily.
Voluntarily.
Otherwise,
then they will
long run procedure.
My lord, eviction will be done.
Other long run procedure. No eviction. Section 4 first.
My lord.
Thereafter section 5A, then section C order, then section 9 appeal, then Mr. Puya will approach under 227.
My lord.
Long run procedure.
My lord, even then
It is not.
This order.
This thing cause of action, separate cause of action.
My lord.
I am not entertaining it. It is up to you. File separate, it is different. This is not possible.
Then, my lord, with liberty, my lord, we may be allowed to.
Definitely, this file separate
My
application,
lord,
separate
my
cause
lord,
of action.
I have also, my lord, not agree with the clubbing together, but hurriedly it had been filed, my lord, so there is
And
a
it is
mistake.
voluntary, and you cannot be evicted.
My lord.
It is clear.
That is there, but my lord, my lord, if we go by the show cause
No,
and
no,
the.
will not so. Firstly, will not go into it.
No, my lord, I am just, my lord, out of the record, I am.
Then I am dismissing it.
No, my lord, I am
If
withdrawing
you
it.
make submission on merit, I am dismissing it. On distinct cause of action, clubbing of multiple cause of action, which is not permitted to be.
Then I may be allowed
entered.
to withdraw, my lord, with the liberty.
You may have a good case.
Yes, yes.
That is a different issue. Third, Mr. A.R. Miyal and Senior Counsel, State Bank. Like counsel for the petitioner. And there must be a standing counsel.
Standing counsel is here, man.
He has to be served.
We have served. Yes, yes, my lord, we have served, my lord.
Name is reflected. Not reflected. Then Mr. Das, you are for?
1 and 3, man.
Okay, Mr. Andas, landed junior government. Three. Mr. Puyan and Senior Counsel submitted that the petitioners can be permitted to put out a petition in order to file individual petitions. In view of the above submission made by Mr. Puyan and Senior Counsel for the petitioners, dismissed on withdrawal from with liberty to file individually.
Smile. Obliged.
Timing methods, item 4.
Please, Lordship. On the 13, so.
Yes, you were standing counsel.
But I appear on behalf of Mr. D. Thousand, my lord. He is the standing counsel, my lord. He is unable to appear today, my lord.
He is not available.
He is not available today, my lord.
Because earlier the court has observed,
my lord,
that no useful purpose will be served by keeping this petition pending.
My lord.
So that is why his presence is required.
Required, my lord.
When he will be available? Because learned counsel for the petitioner is insisting for issuance of notice. Whereas the coordinate bench on the earlier date has observed that I am of the primacy view that no useful purpose would be served by keeping this petition pending, no notice is issued.
That is there.
But at the insistence of the learned counsel for the petitioner, the coordinate bench has kept the petition pending.
That is true. Perhaps in that.
Tell Mr. Borua, we'll take up another date. When
on Friday, my lord.
Huh?
On Friday, my lord. This Friday.
Mr. B. Borua, learned counsel for the petitioner is present on the request of Mr.
I am D. Kolita, my lord.
D. Kolita, learned counsel, appearing on behalf of Mr. D. Thousand, standing counsel, Dimahasa counsel, who is not available today. So this is the case on Friday.
17.
Or Monday. Monday.
Okay.
Monday 2007. Item 5.
I'm going to file an additional evidence by tomorrow, man. Paying for a short adjournment, by tomorrow, I'll file a.
Okay, Mr. M.A. Islam, learned counsel for the petitioner has short listing of, has submitted that an additional affidavit is going to be filed by
Tomorrow, by tomorrow. Tomorrow only after tomorrow.
Friday, by Friday. Date to deliver. Post he has just short listing of the case on another day. Post the prayer is accepted. Please the case on so and so. Miss N. Board, sorry. M. Bormon, 2 and 4, and Miss R. Bora, standing NHAI for the response number 5 and 6 are present.
Lakshmi, fix a date, man.
Next date,
24th, 2407.
I know.
Item 6.
Business lady, my lord. And being a member of a scheduled tribe, my lord. So she's not she's not liable to pay income tax and section of pay.
You have filed ITR. Was it required?
No, my lord, actually, my lord, she received a notice, my lord. In the month of May, March 24, she received a notice. Based, my lord, perhaps, my lord.
No, it is an ITR of some other year.
No, my lord, she received a notice for filing ITR for the years 2027, 17, 18. It was received in the year March 24, my lord. So, my lord, on receipt of this notice, my lord, she approached the tax consultant, my lord, Itanagar. So, he advised that yes, you file notice for filing ITR.
Now, where is that? And it has said, I have seen, as there is an assessment order,
My lord.
right?
My lord.
My lord, that assessment order has already been challenged and the appeal is pending before this.
Wait. I have not asked for your submission right now.
I apologize.
Don't jump the gun.
Lordship.
This is an assessment order,
My lord.
page 21,
My lord.
right? And it says, where is the last part?
Last part is, my lord. Conclusion, page 48. my lord.
Page 48.
My lord.
Page 50.
Yes, last
This is an order passed under section 143 within bracket 3, read with section 147, read with section 144B. Right.
My lord.
Then on the basis of that, this notice has been issued.
Yes, my lord.
Page 51.
My lord.
Now there, clause 6, if you intend to appeal against the assessment, you may present an appeal under so and so. I think that is section 246
Yes, that there also.
A, right? 246A. And that appeal is pending.
Pending. Yes.
And as per law, within what time period?
Within 30 days. Perhaps, my lord.
When did you prefer?
Yes,
When did you
within- my
prefer the
lord,
appeal?
we-
Come to the appeal.
Yes, my lord. Page 53, my lord.
Page 53.
This-
When do you prefer the appeal?
we put, my lord, 20 date of
Date of filing, 4th May.
27/4, my lord.
4/5, date of filing.
Date of filing is.
Oh, sorry.
Page 58, my lord.
Page 58.
27/4/25.
So there is no appellate order.
There is no appeal.
No appellate order. As on date.
As on date.
Yes. What is the time limit for disposal of the appeal?
Lordship, I'll have to check that. There is no specified time limit as far as I.
Don't you say without looking at the book? Everybody comes without the book, without reading the rules. 246A.
Yes, Lordship, I'm on that.
Two 246A is a provision?
Yes, Lordship, the appeal is under 246A.
246A. 246A.
In 246A, Lordship, I could not see any time limit. In fact, section 220 subsection 6 clearly shows the power of the assessing officer. But in the instant case, the application which has been submitted to the assessing officer, Lordship, it does not show, there is no acknowledgement that it has been submitted. And so far as a stay is concerned, there is a office memorandum of the CBDT of 2017, which requires a pre-deposit.
$250 sub
Procedure.
section 6A.
In every appeal, the commissioner appeals where it is possible. may hear and decide such appeal within a period of 1 year from the end of the financial year in which such appeal is filed before him under subsection 1 of section 246A. This is not mandatory in nature, this is directory.
So you cannot, with that, without deciding the appeal, if appeal is preferred,
Lordship,
you cannot go on issuing notices.
Lordship,
You cannot go on issuing notices.
Lordship, I understand. My only submission before this honorable court.
If it is not optional, if it is optional for you to
Directory,
keep the appeal pending for 2-3 years,
No, Lordship. not
and you
at all.
cannot go on issuing subsequent notices.
Lordship, I am not saying on the maintainability of the writ petition. What my humble submission is, since this application does not show any acknowledgement, my only humble prayer is the petitioner may approach the income tax officer because he has got the power under section 220 subsection 6, and he can make an application as per the guidelines. Because
Where is the acknowledgement of the appeal?
there is no acknowledgement. Page
Come to
59.
page 58.
The application, Lordship, application to ITO. The power to stay the demand notice is with the ITO under section 220 subsection 6.
If something is available to the adjudicating authority, ITO, it is also available to the appellate authority. Right? Come to page 58, acknowledgement number.
Yes, Lord.
What this commissioner, appellate authority is doing?
Arunachal Pradesh,
Huh?
27 April. 27 April.
Acknowledgement number is there.
Yes, Lordship.
Is it not?
Appeal has been filed, Lordship. I am not disputing
Appeal
that.
is pending.
Yes, Lordship. Appeal
No,
is
there
pending.
are other issues because one appeal is pending. And appellate authority is also empowered to pass an order which can be passed by the adjudicating authority because appeal is a continuation.
Indeed,
Whatever you are
Lordship.
saying
But
220,
since the power
right? And if something is pending, then a parallel proceeding cannot be permitted.
No, that is true, but my lord, my
You
account.
hesitated that
But my lord,
before the appellate authority.
no, my lord, appellate authority also, my lord, in the appeal also we made a prayer for stay of the, my lord. Then, my lord, we also preferred it for the concern ITO, my lord, Lakhimpur, ITO Lakhimpur, my lord.
No, if the appeal is pending
My lord,
Yes, Lordship.
and that appellate authority
my lord.
is empowered to pass an interim order also of stay,
My lord.
then you should agitate that prayer before that appellate
Yes,
authority.
But my lord, the appellate, my lord, the appeal is in the file, the faceless, my lord, who is, my lord, my lord, who will decide this matter, we are not aware of. It is
Lordship,
in
this is a
manner.
faceless mechanism. That is why I was proposing before this honorable court that he may file an appropriate application before the ITO, not Lakhimpur.
That has been done. my
Lordship,
lord.
there's no
Yes,
acknowledgement.
14/4/2026, that's page 62, my lord.
Whatever faceless for transparency, whatever, but you cannot go on after appeal is preferred on the ground that C is exempted under section that 1026. You cannot go on issuing further demand
Lordship, my only humble submission is
because the subsequent demands are further demands.
let the ITO decide because the guidelines.
Why should?
The guideline, Lordship.
You
issued
make
by
your
the
submission. Otherwise, I am saying everything.
Lordship, the only guidelines, I am only on the guidelines, I'm not on anything else. Either he submits and stay application as my learned senior has.
No, he is not doing anything. Whatever your faceless thing mechanism is there, he is
Lordship.
not doing anything. He is not
Lordship.
disposing of.
It's not like that, Lordship.
It is not. It is a guideline, whatever. But for them, it is.
Lordship, under 220 subsection 6, the ITO has got the power. He
If
must submit
somebody
pro-
does not exercise any power,
Lordship.
neither the appellate authority, it is
Lordship will kindly see
he,
page
the
59 for a moment.
petitioner has a primacy ground.
Lordship will kindly see page number 59 for a moment. Lordship, this application at page 5960, it nowhere proves that an application has been submitted before the ITO.
My lord, it was submitted by
There is
hand,
no
by
receiving.
hand, my lord.
Then you take your instructions.
Yes, my-
I have
Whether-
already sought instructions, Lordship. This application has not been received in the office. And second thing, I have also taken the instruction with regard to the fact whether any pre-deposit has been made since the appeal is pending. No pre-deposit has also
Yes,
been
that-
made,
yes, my
Lordship.
lord. No deposit, because my lord, she is not liable to take, pay, my lord.
No, that is not the way.
But my lord,
That is not the way.
No, my lord.
That has,
My lord-
Mr. adjudicating authority has passed an order,
My lord.
rightly or wrongly.
My lord.
And to prefer an appeal, if request condition precedent is pre-deposit, it must have to be deposited.
My lord.
Thereafter, you can
My lord,
get
they-
refund, that is a
That
different
is-
issue.
They are demanding-
Or
My
if
lord,
there
my-
is a provision for waiver,
My lord.
you have to make an application. But without pre-deposit, if file an appeal, then appeal may not be considered.
My lord, whether the,
Madam, you take your instruction whether
Lordship,
this
will
appeal has
kindly
been,
see that notification. I
whether
have
that
displaced.
appeal has been disposed of or not.
It has not been disposed of. I have sought instructions yesterday only, Lordship. Appeal has not yet been disposed of. It is in faceless manner. And if at all a stay is required, the ITO is empowered to do so, subject to payment of 20% of the disputed demand. The notification I have placed before your Lordship.
my lord, the 20% is also, my lord, it is 9 crore 85 lakh.
See, you have done, because I have seen your conduct. You did not hesitate that issue.
No, in the, my lord, in the reply to SOCO notice, I have hesitated this issue, my lord. In the reply to SOCO, not after filing ITR, my lord, another SOCO notice was issued. Then in the reply, my lord, we have hesitated all these issues. My lord, that is a page, my lord.
That
Now-
is subject matter of appeal.
No, not prior to it, my lord.
The same issue cannot be
Page-
adjudicated
no,
before
no,
the
no, no.
appellate authority
It
as
was
well
not-
as this honorable
It was
court, Lordship.
It was prior to, my lord, appeal, page 16, my lord. Page 16 of my reply.
Mr. Gore, we do not entertain a parallel process. I have already held. Where is the reasoning in the assessment order?
No, assessment order, my lord, there is only.
Where is the reasoning
It is-
regarding
yeah,
your ST status?
Yes, my lord. No, regarding my STs, there is no challenge, my lord. They are not disputed it.
No, please take me to that.
Yes, yes.
Please take me to that.
Yes, yes. My lord, page 33, my lord.
Page 33.
Very good.
So you did not file anything?
No, my lord,
Documentary evidence.
No, Mr. Gore,
my lord, in the, my lord, in the.
page 33,
Yes,
page 33 in the
yes.
present case,
My
fourth
lord.
line.
The SSE has not filed any documentary evidence except a trade permit for shops. The name of this.
My lord, page 29. My residential certificate, my lord. Page 29 is, my lord, the type copy. 29A is the, and page 30 is, my lord, tribe certificate. Page 30, my lord. Page 30 of the, this, it is, my lord, it is a part of the same assessment of the money.
Where is your ST certificate? ST certificate annexed?
Yes, my lord, page 30, my lord.
Page.
Page 30.
30.
It's not at all legible.
This is to certify that Miss Andre Ketsi, daughter of such and such, my lord, belongs to I do Missimi tribe, which is recognized as scheduled tribe.
And this is part of the assessment order, my lord, how the learned assessing officer
No.
can.
And you have applied, you have submitted an appeal. An appeal is pending, right? So an order which can be passed by an appellate authority, when the appeal is pending, another parallel proceeding cannot go on.
No, I'm not,
Right.
my lord, I'm not challenging this, my lord. So-
Regarding that,
My lord,
regarding,
My lord, my challenge, my prayer is my lord, that during the pendency of appeal, my lord, they, after filing of the appeal, my lord, they have attached my bank account, my lord. So, by, I am agreed by the.
under which power?
My lord, on the basis of my lord, altering demand, my lord, they can attach my property, my lord, that is true, my lord. On the basis, my lord, if my any demand is against me, my lord, in that case, they can attach, that is there, my lord. But, my lord, the fact, my lord, that I am belonging to, my lord, scheduled tribe, my lord, and my lord, there is no, my lord, there is no allegation that my earnings, as shown, my lord, in the assessment road, was not within the state of Arunachal Pradesh. If, my lord, that is the position, my lord, I am not at all liable to pay any tax, my lord.
That I understand. On that count, I'm with the petitioner, 1026. But question is that an assessment order has been passed by the adjudicating authority. Challenging that assessment order, you have preferred an appeal, right, under section 246A,
Yes.
right? And that appellate authority, whatever faceless, is in season of the appeal.
My lord.
And that appellate authority, like an assessment or whatever, perhaps he is empowered to pass a stay order.
My lord. Yes, my lord.
Right.
Yes, my lord.
He did not pass.
My lord.
Now, when the parallel proceeding, a stay order has not been passed. It is difficult for us to entertain the same prayer.
Yes, but,
Right.
but my lord, as my learned
Any demand arising out of that assessment order.
But my lord, as the assessing of my lord, this ITO is empowered to my lord.
Then she is saying,
She is saying, my lord, but my lord, then
there
my
is
lord,
no
then-
acknowledgement.
my lord. Then I can, my lord, I can also obtain whether my lord they have any acknowledgement or not. So that
You
I
have
can say, my lord,
acknowledgement,
then, my lord,
otherwise you have to go by this office memorandum.
my lord. No, in the this my lord.
Then 20% pre-deposit issue comes.
Yes, my lord, that is. Yes.
Nothing. Tried, but no, maintainably will be considered. Will issue notice at this stage. Because you have not made out a primary case for, because appeal has to be pre-deposit.
My lord, that
And
is
pre-deposit
that-
will,
yes, but my lord, this-
otherwise in other acts, if pre-deposit is made, it is automatic stay.
my lord. But my lord, the
Right.
Yes.
But there might be provision in CGST Act. If pre-deposit is made, it is automatic stay.
My lord. But my lord, this very heavy amount also is not in a position to deposit.
Otherwise, you are a rich person.
Yes,
No,
Lordship.
no.
Yes, Lordship.
It appears to be a rich
Yes,
person.
Lordship.
No, she is not a rich person.
You have so many deposits. Yes. What do you
No,
say?
she is not a rich person.
What do you say?
Some time will be allowed, then I will obtain instruction whether this.
If deposit is there,
No,
second,
deposit is certainly not there.
then it's not
not there,
judiciable. Unless it is adjudicated. And if there is any provision for waiver,
That perhaps my lord, I am not whether any such application was made or not. I am
whether,
not-
no, first there has to be a provision for waiver of pre-deposit.
No, Lord.
Right. So find out.
I'll
If there is so, I will permit you to file an application before the appellate authority for waiver. If since appeal is not disposed of. And if that waiver is not made, order, then there will be automatic stay.
Yes.
Find out. Okay, I am keeping this office memorandum on record.
Yes, Lord.
Third, Mr. J.C. Gaur, and counsel for the petition. And Miss Dr. P. Agarwal.
Senior standing counsel.
Senior standing counsel, IT department, for the respondents, for all the respondents. On the request of Mr. Gore, please the case when?
Next week.
Wednesday.
Wednesday, Lordship, I have some difficulty on Wednesday. Any other day?
Friday.
Friday, Lordship.
Matter pertains to Lordship, dwelling house Lordship, ancestral property Lordship. The father had built 4 houses Lordship. 2 houses were given to one son, elder son, to the younger son. My petitioner Lordship. And the petitioner serves in Lordship, Golaghat district Lordship, in Moligo refinery, while his residence is here, the ancestral property is in Hazo area Lordship.
Petitioner Monturam Das.
Lordship.
Yes.
While he was there Lordship,
Hmm?
he came and
Ancestral property,
Lordship. 2 houses Lordship
2 houses.
belong to him, 2 houses belong to his elder brother. Lordship. While he was there, Lordship, in May 2026, he returned and saw that his house was completely demolished, Lordship, by the elder brother. Completely
Elder brother.
elder brother, Lordship.
Hmm.
So, and thereupon, he had built some RCC structures, Lordship. When he approached the police, Lordship, he was threatened not to come. He went to the police, tried to file an FIR, Lordship, register an FIR. Police said, no, we are not accepting you. This is not the proper format. So again, he filed a second FIR, Lordship, which he thought would satisfy the police, Lordship. But that FIR has also not been accepted, Lordship. We had also approached the district commissioner, Lordship, and the district commissioner had initiated an inquiry, but result till date is not here, Lordship.
Takari.
Apparently, it's a private dispute, Lordship. So whether interference by the district commissioner. And regarding the lodging of the affair, that is also
Takari Vasu.
156(3).
Lordship, I know it is a civil dispute, Lordship, that will be there,
Regarding
but the breaking down of demolishing of the house, taking of my property,
If it is a criminal act-
threatening me, Lordship, those things will.
Yes, non-registration of the affair is the prayer.
Lordship, that exactly is my prayer, Lordship.
Yes. That exactly is the reason why the petition is not to be entertained.
Lordship, I have approached the SP also, Lordship.
Then have you approached the jurisdictional magistrate?
Lordship, usually what we do, Lordship, we
That is-
approach the SP.
Law laid down is that. Otherwise, Supreme Court has held that if this kind of writ petition is to be entertained, thousands writ petitions should be filed. So you have to approach under 156(3), now 273.
Now, most probably it's 175. 175.
Read with something.
Lordship.
No, this way. You file a complaint
Lordship,
before the magistrate.
Lordship. But for the emergent nature, Lordship, I came here, Lordship, because
No, that is not the way. We cannot entertain this kind of writ petition. Heard Mr. M. Bhagavati, learned counsel for the petitioner, and Mr. A. Sharma, learned additional senior government advocate.
For respondent number 126.
For the respondent number 126. Para. In this writ petition, preferred under Article 226 of the Constitution, the petition has canvassed that he is the owner of a residential house situated in village Dodora, police station Haju Kamrup, district Kamrup. Full stop. It is stated that the house has been inherited by the petitioner from his father, late Tonuram Das. And the house is situated on a plot of land covered by Dag number 564 and periodic patta number 71, situated at village Dodora, Hajur Avenue Circle, District Kambu. Subject law. Bottom line কাটি দিব. His father, it is stated that his father had built 4 residential houses on the subject plot, and out of those, and out of those 4 residential houses, 2 have been provided. 2 of the houses have been provided to the petitioner, and the remaining 2 have been provided to his brother, Sri Hemanto Das, who has been arrayed as respondent number 7, who has been arrayed as party respondent number 7 in the instant writ petition. It is further stated that the petitioner and his brother, when the respondent number 7, have been residing in their respective share within the subject plot, but in separate houses since the date of their father on 10/12/2024. Post of para, subpara. The petitioner has further stated that he is presently employed in Numaligarh Refinery Limited and is posted in Gulagarh district. Post of. In the month of May 2026, the petition has come to learn that the residential houses where he used to reside have been completely demolished by the respondent number 7, without any intimation to the petition. Post of. The movable property, apart from demolishing the houses, movable property worth ₹5 lakh have also been taken away by the respondent number 7. Post of para. In the above backdrop, the petitioner submitted a first information report before the officer in charge Dodora Police Outpost. Before the in charge, Dodora Police Outpost on 20/05/2026, narrating the alleged illegal acts of the respondent number 7. But the said FIR was not registered by the in charge Dodora Police Outpost. Agreed by such non-registration, the petitioner approached the senior superintendent of police, Kamrup Aminyao, and had filed a representation on 16/6/2026. Post up. As no action is taken either on the FIR dated 25/2026 or on the representation dated 16/6/2026. The petitioner has approached this court by the instant writ petition seeking inter alia direction to the respondent number 6, that is the in charge Dodora police outpost, to register the FIR to seeking inter alia direction to the respondent number 4 and the respondent number 6 to register the FIR dated 25/2026 and stroke or the representation dated 15/6/2026 for making investigation into the case. Post up. Mr. Sharma, learned. Additional senior government advocate appearing for the respondent number 1 to 6 has submitted that in the event the FIR stated to have been filed by the petitioner, disclosing any cognizable offense, disclosing commission of any cognizable offense has not been registered by the jurisdictional police, the jurisdictional police station, then the petitioner has to approach the jurisdictional magistrate as per the provisions of the Bharatiya Nagorik
BNSS.
Nagorik Suraksha Sanhita 2023 within bracket BNSS. Within bracket as well the Code of Criminal Procedure 1973. Post up. He has referred to the decisions of the Honorable Supreme Court of India in Sakiri Basu versus State of Uttar Pradesh and others, 2008, 2 SCC 409, Sudhir Bhaskar Rao, Tambe Nikita, Sudhir Bhaskar Rao, Tambe, sorry, look at it. Versus Hemant Yaswant Dhage, 2016, 6 SCC 277. Recent BNSS, the colony vote. Recent, 2000. Like 175, right? 173 for BNSS.
That was, I am inquiring, Lordship, under what provision, Lordship?
It is there. I have already held. I have disposed of.
Yes, Lordship.
50 number of cases already.
Lordship, he told me that thing, that Lordship had disposed of another.
BNSS from Johnson of the request. Old.
Oh, thereafter, BNS has also been interpreted by the Supreme Court.
Yes, Lordship. In
There are a number of, 3-4 number of decisions.
What happened, Lordship, earlier?
Earlier
we used to-
already কষ্ট করে লিখা আছে।
Lordship, earlier we used to get orders from this High Court, Lordship, so I thought it that way, Lordship.
Okay, I'll dispose of. Let me find out.
Lordship.
173, 4 SSC read with BNSS read with 175 something.
Yes.
And there are 3-4 decisions of the Supreme Court following Sakari Bosu.
Yes.
You permit to go jurisdictional magistrate, file a complaint, complying with an supported by an affidavit.
Lordship.
Disposal. File you. Today, Bhaskar update line. Oh, you have to put to it. Hey, Aru আছে Aru latest একদম latest আছে চোখ মই 12
Order no steps. Item 12.
Yes.
Lordship, kindly grant us some time. We need to take steps.
You are Mr.
Erika.
Mr. Edeka, learned counsel for the petitioner has sought for further 2 days time to take steps upon the respondents in deference to the order dated 29/5/2026. The praise allowed, the petitioner shall take steps for service of notice. Invariable steps upon the respondents by speed post. Invariably, within 2 working days from today, so it is observed that in the event no such step for service of notice upon the respondents are taken by the petition, then the writ petition would stand automatically dismissed without any further reference to the court.
Obliged.
For admission, items 15 to 18.
Your Lordship, Lordship, in these matters, we have received the counter affidavits today, so we need some time, Lordship.
What is this?
Non-payment of contract.
Transport,
Yes.
Miss
It's P. Kaklari.
P. Kaklari. B. Bombay. Punjab.
V for Vanish.
Oh, Venice. Okay, P. Kaklari, learned counsel for the petitioner. Miss R.M.
Deka.
Learned standing counsel, Water Resources Department for the respondent 1 to 4. A. Gayan, learned central government counsel for the respondent 6 and 7. And who else are present? Learned counsel for the parties have submitted to the subject matter of these petitions pertains to transport. So, in view of the above submission made by the counsel for the parties, the registry is to verify about the subject matter and thereafter to list the cases before the appropriate.
Yes, that's why ASIDC.
Mr. S. Das, standing counsel,
ASIDC.
ASIDC. What is that? Well,
All is discussed.
today there is a matter, I think,
Bimbo.
before the appropriate.
Lordship, date may be fixed.
I cannot fix.
Item 19.
File your reply in the meantime.
Make results.
Yes.
This matter relates to a road matter, construction of a road. If your Lordship will kindly see page number 12. That is the schedule matter. The petitioner is the owner of this plot of land, 1 bigha 2 kata 10 acres of land covered by DAG number 21. And these are the boundaries matters. Now, if your Lordship will kindly have a look at the map, page number 22A. 22A.
No, they are supposed to carry out a verification.
Yes.
Where is Mr. B.J. Taludar? Because that submission was made on receipt of instruction.
Yes. But we received notice for on fixing a date. Date was fixed for verification, madam. So we do not know about the report. Some verification was done.
Any thing on record?
It was 13/7/2026.
Last listed on 27/5/2026.
One report has come because this case was attended.
Let us have a look.
Please absent.
That regarding paragraph number 13, 15 and 17. এইটো হেৰি 20 নম্বৰ দাগটো হেৰি ৰাস্তাই
Firstly, no road has been constructed till date.
Lots. They attempted to construct, but because of an interim order, the construction was stayed. Our
And
houses
if
were
your
demolished.
if your losses go by the trace map after 2 or 3 pages, the whole the road itself is that stress itself is dark 20
Yes.
and encroachments are there lots.
The only dispute was that the opening of that road covered by Dock number 20 was over the petitioner's land. That is Dock number 21. That is the only dispute. The road ought to have constructed dissecting 19 and 21 on the western side.
For our contention is that lordship there are encroachment in 20, so that is to be removed.
If encroachment is there, there cannot be high-handed action. There cannot be high-handed action. There has to be made encroachment free as per the procedure.
Yes, lordship, and in our affidavit we have stated that encroachment is removed by following the due process of law.
To us, what is the due procedure of law? Anything
that due
to
process,
anything to substantive?
lordship.
It is very easy to say. Which paragraph?
The paragraph number 6 of our affidavit, page 31. Affidavit by respondent number 5.
What is due procedure?
Which is recorded as government, the petitioner was served notice and was given ample time to remove.
Then I can outrightly dismiss him. Where is the notice? He is silent.
No,
He said forcefully.
In our affidavit, we have stated that stated but not annexed that notice.
Give the notice annexed, then end of the matter. We'll not go into the other disputed questions of fact. Notice is available.
Lordship, let me. No, notice is not available. Notice is not available, but what is their reply to our paragraph 6, Lordship? Wholly false, concocted, misleading, and clearly an afterthought.
Because you have not said also
Lordship.
that by serving notice, So he
But it is
is not
specifically
required.
denied.
No, Lordship, we
It
have
is denied,
stated,
ma'am.
but it was denied by
It is
them.
specifically denied
It
that
was
any
denied
notice
by
was served. Specific denial.
Ah. Any notice was ever served.
Lordship, that was denied by them.
Within quotes, my lord, ample time was granted.
You put us in difficulty.
Lordship, may I pray for some more time to get that, if that notice is served or not, Lordship? If the
I
notice is,
don't think he has categorically said now.
Lordship, it was stated. Yes, that is why, Lordship, if your Lordship gives us some time, I can bring that notice if it really served.
And my lord, that report may also be filed on affidavit so that I can reply.
Reply to the reply.
It says Dag number 20 is government land.
Yes. That is a
Dag number 19 and 21 are periodic patta.
Yes.
21 you are claiming.
Yes.
Proposed public road has not yet been constructed. On the ground, it is not yet constructed. Therefore, the road has already been built through the petitioner's patta land and house is false. Field verification report shows that portions of Dag number 20 are under unauthorized occupation by certain persons, including the petitioner. If any notice under 18 is served, Rule 18 is served, then after it has to take its own procedure.
Lordship.
After hearing Salakuddin and all. But no, if the notice is there, then I can dispose
Yes,
of that.
Lordship, that is why, Lordship,
Directing the circle officer to pass a region order.
Lordship,
That's all. We can, that much we can do.
let us verify whether notice is served or not.
Yes, Mr. Nath, are you aware of any notice?
No, my lord, that is by the administration for 123 the PWD department.
Yes. Notice. Okay. And Mr. S. Das, learned counsel for the petitioner, Mr. H. Sharma, learned additional senior
No, no,
advocate for the respondent number 4 and 5, and Mr. D. Nath, learned standing counsel PWD for the respondent number 1, 2, and 3. Full stop. Having regard to the claims and counterclaims made by the learned counsel for the parties, it appears appropriate to ascertain whether it is noticed that the state respondents have alleged that the petitioner, who is the periodic patta holder of a plot of land covered by Dag number 21, has encroached upon areas, a part of the government, a part of the land covered by government Dag number 20, which is reserved for road in the land records. First of the Mr. Para, in the above view of the matter, Mr. Sharma, additional senior government advocate, has submitted that he will ascertain, he needs some time to ascertain whether for making the plot of land under government Dag number 20 encroachment free, any notice has been served upon the petitioner who is in alleged unauthorized occupation of a part of it, of a part of government Dag number 6. Lays the case after 2 weeks.
Lordship.
Lays the case, video on to enable Mr. Sharma to obtain the necessary instructions.
Copy of the report.
It is nothing there. If notice is served, it will take its own course.
Sir, interim is also.
We are not interim. The interim of the past idea should continue till the next.
May I get back that report?
But produce it on the next day.
Lordship.
7th August. 0708.
It is 20 and 21 only.
Lordship. Item 22.
I'm sorry, Lordship, I was supposed to file my reply, that's why.
How much time you need?
So 4 weeks, because
Mr. J. Kolda, learned counsel of petitioner has sought for and is granted 4 weeks time. Further 4 weeks time to file an affidavit in reply to the affidavit of opposition filed by the respondent for post of Miss M. Bormon. Learned Junior Government Advocate Assam for the respondent number 2, 3, 4, and 5 is present.
Lordship.
The learned counsel for the respondent number 1 and 6 is found absent to be on.
Apply.
Release the case accordingly after 4 weeks. The date will be fixed by the office.
25. Second copy to your.
Yes, madam. No counter till date. Heard Mr. A. Manaf, learned counsel for the petitioner. Revenue? No revenue. Miss M. Bormon, learned Junior Government Advocate Assam for the respondent number 3, 4, 5, and 6. Present, Ms. M. Bormon has sought for further 3 weeks time to complete the instruction and to file the counter affidavit on behalf of the state respondents. The prayer is allowed. Release the case on switch.
August, my lord. Obliged.
Item 26.
Lordship, I apologize on last occasion. I missed the item, Lordship. That's why I could not be present. Lordship, I have received certain instruction, Lordship, which I want to bring through affidavit, Lordship.
You are
There
looking
is,
for 4 and 5.
Lordship, the municipal board, Lordship. There is a deed of agreement between the parties, Lordship.
Bring on record
That I, Lordship.
deed of agreement between parties.
Yes, Lordship. Petitioner and the private respondent, Lordship, in 2019. And on the basis of this, Lordship, the building permission was granted by the authorities, Lordship. And subsequently, as the building was already constructed, it was half done, Lordship, and it was subsequently renewed,
At
Lordship.
that time, relationship was tweaked.
Yes.
Now it has turned so.
Lordship, seems to be so, Lordship.
Yes, Mr.
L. Deka.
L. Deka, learned counsel for the petitioner. Mr. H. Sharma, learned additional senior government advocate for the respondent number 1, 2, and 3. And Miss U. Nanda, learned counsel for the respondent number 6 are present. Post of Miss M. Authorised, learned counsel appearing for the respondent number
4 and 5,
4 and
Lordship.
5 has submitted that on the previous date of listing, comma, the item was missed and therefore she could not be present on that day. Because of Ms. Parasi has submitted that she has received the necessary instructions to file the counter affidavit.
One affidavit, Lordship, we already have filed.
No, on the point I have
Yes, Lordship, on Lordship's observation.
traversing the points
Lordship.
recorded in the order dated
Yes,
25/5/2026 and has sought for how much time?
2 weeks, Lordship.
3 weeks time to file the counter affidavit. First, the prayer is allowed to raise the case on such for filing of counter affidavit.
Lordship.
Filing of additional affidavit
Additional affidavit, Lordship.
in opposition by the respondent of 4 and 5.
Lordship. Deeply obliged. August.
12 or 11.
12. 12 August.
Deeply obliged, Lordship.
Item 27.
May please your lordship. Conducting counsel, Mr. M.A. Hussain is in error. Could kindly kindly postpone the matter for the time
Response
being.
number 8, where is response number 8? Miss R.D.B.
Court number 10. Says in court number 10. So in lakes or?
Otherwise, our membership will go.
Yes.
Panchayat member.
Panchayat. Or some other day, my lord, our affidavit.
Otherwise, you will foreclose on the previous date, short time,
Yes.
1 week. Okay, we'll call after something.
Election petition is also pending, my lord.
Huh?
In the tribunal.
Election petition. No, what is the ground for seeking disqualification?
False affidavit, my lord.
False affidavit.
False. Child was below 21 years of age.
False affidavit. Oh, child marriage.
Child marriage.
That may not be a case of election petition.
But it's already filed. They have
Filed, but that may not be. Please inform Ms. R.D.B. Right, we'll take up after some time.
after September.
Item 29.
Yes, Mr.
May
Patra.
please, your lordship. That's a new subject for me, my lord, but I'll try to assist your lordship.
CGST.
My lord.
Right, this is not new for me also.
My lord, what had happened, my lord, the petitioner, my lord, the
Insurance ombudsman
respondent had, my lord, obtained a marine policy.
and Mr. Mishra is for whom?
The sole respondent, madam.
Sole respondent.
Madam.
Ganapati.
My lord.
Marine policy was taken, my lord, by them.
Hmm.
And my lord.
Just give him,
Yes,
if a pleading is exchanged, then
My lord,
we'll hear him
sorry.
we'll hear you on a hearing date.
My lord, my lord.
But just give me a gist
Lordship. I'll just.
without going to the brief.
Yes, my lord, the respondent had obtained a marine policy. To cover
Marine
the
policy
The transit of goods, my lord.
through waterways.
No, my lord, it's a open marine policy which covers the road transport also.
Okay.
So the lordship, the truck was moving and it was found that trucks on a particular day it suddenly went missing. They filed an SR. Accordingly, the investigation was taken up. At the same time, they had lodged a claim with the insurance company, claiming the transit loss, my lord, the entire loss they have claimed. In the meantime, my lord, what has happened?
It was carrying some transshipment.
Yes, yes, ma'am. Lordship is aware that during that period, lot many trucks have gone missing, my lord, just to evade the take the benefits of the record, but take the benefits of the GST, my lord, the component which is on the portal.
Which time? Which time?
Sometime in the year 2022-23 and all.
Okay.
So the same incident had happened, and they had lost a claim with the company, seeking the whatever loss had incurred. They wanted to get it recovered from the insurance company. Insurance company, my lord, they had appointed a survey. The survey was done, assessment was done, and it was found that yes, the loss had in fact had happened, and they agreed to a sum of rupees 8,17,000, which we agreed. The assessment survey report was there. We offered them, they refused. Now their claim was that we had paid GST and we had not taken the input credit. So because of that, they wanted to club the input credit into the total invoice amount, and they wanted the claim from the insurance company. We refused, we rejected their claim. They went to insurance ombudsman. Insurance ombudsman, my lord, before going to the insurance ombudsman, they had gone to the grievance cell of the company, which had gone into details of the matter and my lord found that GST component is still lying in the portal, which they have neither issued the credit note nor the sales returns are done. So that benefit, and because of their lapse in not issuing the credit note as provided under section 34 of the GST Act, the insurance company cannot be blamed. The recovery cannot be done from the insurance company. They wanted to take a double benefit. Because of that reason, we we filed a objection to the ombudsman. Ombudsman, my lord, engaged an independent chartered accountant who advised them that if the respondent gives an affidavit that we are not getting any input credit or we have not issued the credit notes, then in that case, a certain amount is to be paid by the insurance company. If they give an affidavit, they don't have to, if they comply with the giving requirement of the affidavit, then the entire amount, including the GST, is to be paid by the insurance company. So against which we have come before this honorable court. And my lord, on last occasion, my lord, this notice of motions were issued, and my lord, we had taken we had made a submission that we are ready to deposit whatever amount we have admitted. So accordingly, we had sought a leave from this court, and court has granted us a leave, my lord, by the order dated 9/2/2026, my lord. And this amount was deposited.
So this 10,90,059 is what, which component?
My lord, this is without
GST.
Without the GST. That we have accepted and we have deposited also. Our contention was that until unless the
Okay, I will hear you. On the fixed it.
pleadings are completed.
Second part of the video, second. But Mr. R.K. Vatra, Learned Counsel for application, and Mr. R.S. Mishra, Learned Counsel for the sole respondent, who have submitted that the exchange of pleading is complete. First of, in view of the above, as the exchange of pleading is complete, Rama will raise the case on so and so as sought for and agreed to by the Learned Counsel for the parties.
13 August, 1308.
Or the interim or the past side shall continue till the next. Yes, what is your claim?
My lord.
GST, if we input, this is available in the portal.
No, we are seller. We cannot avail ITC. We have already paid the amount to government exchequer. Now purchaser.
Seller means.
I am the seller. I have dispatched the goods. My liability towards output tax liability, which I have already made to the government. Purchaser is not availing input tax credit. And there was two survey report, my lord. First survey report was in.
Purchaser, he is not there.
No, purchaser is not there because the
It is lost.
goods did not reach the purchaser. And my lord, there is a requirement of filing, my lord, the credit notes are to be issued. There are certain
Okay, we'll look into it.
process to be followed.
The
They
next
did
day
not
we'll
follow.
look into it.
Oblige.
Lord, I refer to order dated 18/6/2026. Here, my lord, my petition for sale permission was rejected. It is alleged in the affidavit in opposition. That is not annexed with the record, my lord. So your lordship directed to produce that.
Yes. An affidavit.
Sorry, for order. 28/11/2025.
Rejection order. Sale permission application, rejection order. Paragraph. In which paragraph it is mentioned?
My lord, paragraph 5, affidavit in opposition. So my lord, in page 25,
Page 25.
it is stated that seller buyer so and so rejected last one. Were unable to submit any documents showing their three generation continuous residency in the village so and so. The NOC for the sale permission application number so and so dated rejected on 28/11/2020.
চিঠি এনে লিখলে জমিতে ভয় নেই। Well, I need some further time. madam. চিঠি এনে লিখলে।
28/11/2025.
I need some time.
And bring these notifications also on record. These government orders you have mentioned.
My lord, page 28 is the Assam Gazette notification, my lord, where it has been clearly mentioned, my lord, the definition of the original in evidence. It says, my lord, a person along with his family who have been residing in that area for the 3 generation. In this connection, my lord, they fail to show that they are the residents of the 3 generation.
Anyway, the previous.
Moreover, this is also not under salience, my lord.
Previous order.
My lord, yes, I'll comply with it.
Rejection order.
Yes, yes.
Okay, heard Mr. M. A. Sheikh, learned counsel for the petitioner. Aforesaid, learned standing counsel, Revenue Department. For the respondent number 1 and Mr. Nan Das, learned junior government of Assam for the respondent 2 and 3. Post of Madam. Mr. Das has sought further to extend to bring on record the rejection order dated 28/11/2025.
Yes, my lord.
By way of an additional evidence.
Addition.
So the praise allowed, lays the case on.
After 4 weeks, my lord. No, no,
Rejection
later.
order only.
My lord, a date next week. My lord.
3 weeks.
10/08. Item 31.
Mutation on the base of process. The last occasion, my lord, was. I got the instruction, my lord. It says, my lord,
Somehow, my lord, in this honorable court, exactly similar matter already disposed of by directing the first appellate authority to dispose the petition by setting aside the appellate order.
setting aside. এইটো কৈছে যে কেঞ্চেল কৰিছে আছিল এইটো ৰেজিষ্টাৰটো হৈছিল উইদাউট চেল পাৰমিশ্যন আৰু এইটো এগ্ৰিকালচাৰ লেণ্ড হয় হ'ব নেকি ইয়াতে?
Yes, NOC was there.
No, my lord.
Assam amendment is also there, right? It clearly says.
At that, my lord, at that time, my lord, page 28.
When was the registration?
Registration did, my lord, at page 18, my lord.
18.
18, 18. And in particular, page 20 onwards.
Amendment হৈছে।
But whether you have applied for any NOC?
No, my lord, at that moment of time, my lord,
It has come into effect from when?
I annexed the Registration Act, my lord, amended Act, my lord.
Page 26.
Page 26, my lord.
Yes.
And thereafter, my lord, as per that clause, my lord, NOC is necessary. Subsequently, my lord, it is amended that Annex 5, page 28, my lord.
You purchase the land as well as house.
Yes, my lord.
For house, it is okay. But for land, the NOC is required. See, house, flat, residential apartment. If you purchase a flat
yes, ma'am,
in Gauhati, you don't need section 21 permission.
Yes, ma'am.
But
It
if you
is-
purchase land, then you need permission.
At the time of purchase, my lord.
But it was in 2022.
Yes, my lord. And that act is 22, my lord.
No,
That is
that
amended-
act in 2021 perhaps.
My lord.
What is the original amendment?
Original amendment, my lord,
2021 or
is
with effect from this provision has come with effect from when?
it is, my lord, with effect from
2009.
24th February 2022.
Notification.
Notification is
2009.
Subsequently, my lord, it is amended, my lord.
No, this amendment.
It is, my lord, original act was amended by. It is, my lord, amended in 2009, my lord.
Yes.
Subsequently, that amendment also again it is remodified.
Remodified, whether
that part I annexed, my lord, with my
registration act. Okay, file the affidavit then. Let them file affidavit with the instruction. Heard Mr. K.U. Amir, learned counsel for the petition. aforesaid revenue 1 and thus
2-3.
Post of Mr. Rasa submitted that he has received a revised replies to comments for filing of the counter affidavit on behalf of the respondent number 3 and has sought for further 2 weeks time to file the counter affidavit. The prayer is allowed. Release the case on so and so.
10th August.
It would be
Item 32.
Bring the gazette notification
Yes.
of 2009 on record.
May I please, Lordship? Lordship, this matter relating to acquire of land and compensation, Lordship. Lordship, kindly see the last order dated 25th of May, 26 was directed to obtain the
My lord, in this case, go. Land is a toji land, government land. So compensation cannot be given. Only I'm seeking the necessary document in support of my claim. That is yet to receive. Otherwise, I have got the para-wise commitment.
So Toji land, Toji Patta.
Toji Patta.
And I was paying the revenue also, Lordship, and the allotment certificate, page 14, Lordship.
Page?
Page 14, Lordship. It was allotted in 1976 to.
Toji land,
against
it's a
my
fine.
father. Page 14, Lordship. Ularam Bora is my father, Lordship.
It's a fine.
Yes, Mr. Mitra, you are filing also an affidavit.
My lord, I want to point out, yeah, I want to file, but the thing is that, DL has supposed to issue, they have failed to file the notice under PMP Act, under section 3161, they have not yet. And one thing I just point out, page 8, they have stated himself, page 8.
Page 8 in the writ petition.
In the petition. He has submitted one representation, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 lines from upper parts. In the said petition, representation was mentioned that petitioner earlier submitted representation to a circle officer, Badali Revenue Circle. But the same was rejected, saying the competition not intended on the said land. They himself admitted.
Yes, it is part of record, Lordship. I have submitted the application where it was said.
Land submitted is government land.
Is it?
Toji
land.
Revenue is just
Even though the
They are supposed to give data, they have received a notice of 31.
It is right of way or right of user?
Right of user.
Right of user.
Yes.
That is a fine, my lord. The revenue they are saying that I got the paid revenue. Toji is a fine ultimately. Or enjoying the land, my lord. That is.
And it's still
You filed a counter?
No, my lord.
File a counter.
I'll file it, my lord.
Draft is for 4 and 5.
My lord, yes, ma'am.
4 and 5. You are for
3.
3. Revenue. Heard Mr. S. Ahmed, Land Counsel for the petitioner. Ms. Ann Bordole, Land Standing Out of Revenue Department for the response number 2. Mr. S. Mitro, Land Counsel for the response number 3. And Mr. N. Das, Land Junior Government Application for the response number 4 and 5. First of Mr. Das has submitted that he has received instructions partly.
Yes.
And has sought
To support the claim, documents has not been received.
And has sought for further 4 weeks time to complete his instructions and to file the counter affidavit on behalf of the respondent number 4 and 5. First of, you are also granted time.
Yeah.
Mr. Mitra has also submitted, as has sought for 4 weeks time to file the counter affidavit on behalf of the respondent number 3. Most of the above prayers are allowed. Release the case on suits after 4 weeks.
1708. Item 33.
Morning, something else.
Yes, my lord, bring for my time.
You have some of this.
Objection, because my lord, the
What is
construction of the
offering?
dispensary.
Yes, no, I don't. I was for what?
Modification of the order, my lord.
Okay.
No, sir.
Mondal.
Oh, acha.
Yes, what is your prayer?
My lord, I could not file, my lord, the objection. So, my lord, 2 weeks time may be granted for filing my objection.
Further 2 weeks time?
Yes, ma'am, further 2 weeks. My lord, some medical issue was there.
Hmm?
Some medical issue was there, my lord.
Medical issue?
Yes.
You are for?
Mondal, my lord.
Mondal?
Yes, my lord.
Why Mondal is included?
My lord, I don't know, my lord, why irritated party, my lord.
Okay, and Mr. M. Smith, Learned Counsel for the applicant respond number 7 and 8. I go to it, I go to RS1, 1 to 5. Who is for central government? Ms. M. Das, R. Dr. Learned Counsel on behalf of Mr. S. K. Miti. And a central government counsel for the opposite party number 6. N. Bordoloi, Revenue 7, OP 7. Mr. N. Das, Learned Junior Government Application for the OP number 8, 9, 10, and 11. And Ms. Which for 12? OP 12?
12 was 110.
No, no more. It took 9.
Pabon Deka, last Monroe, AM Ahmed.
Ahmed.
Council for the OP number 12.
9 million as per read petition.
No, IA. We are into IA.
I don't know. I have not received any.
I'll provide it.
Okay, Mr. Chauhan has sought further 2 weeks' time to file objection on the ground that he has some personal difficulty. He has some personal difficulty to file the objection in terms of the prayer order dated 27/5/2026. Poster. The prayer lays the case on so and so.
No, my objection may be recorded.
As Mr. Chauhan has cited, though Mr. Smith has expressed urgency in the matter, in view of Mr. Chauhan's submission that due to health issues, he could not file the objection in time. The prayer for further 2 weeks' time to file the objection is accepted. Please the case also. So your objection is recorded.
8 minutes fix, my lord.
12th August, 1208.
And the disputed amount is 22,000 euros. So that can be kept in line and the rest can be.
We have no objection.
Please come up to 10.
2-3 days before I passed an order. How is that? Heard Mr. K. Deka, learned counsel for the petitioner. Case number?
WBC.
You are for Mr.
B. Sinha.
BC?
B. Sinha.
B. Sinha. Learned counsel for the respondent number 2 and 3. Do you have the number? No, I'm dictating.
This was last
Why
week.
should I apply my mind if it is covered? Where is the statement?
It's in page number 35, yes, the counter.
Clear. In this petition, instituted under Article 226 of the Constitution of India, the petition has assailed an action on the part of the respondent in bank authorities in keeping the petitioners bank account number 18700-230-8069 in freeze condition. Poster. It is stated that the petition has been maintaining the same bank account at which branch?
The branch is Nagaon branch.
No.
At Nagaon branch of the respondent in the same bank. It is the case of the petitioner that the petitioner had a deposit of rupees 2,30,360.31 in the said bank account on 28/1/2026. It is a further case of the petitioner that on 27/6/2025, the respondent number 3 had informed the petitioner by communication of event date to the effect that the said bank account of the petitioner had been placed under a quote, no debit freeze, unquote, on the basis of a communication received from Cyber Cell Police Station, Coimbatore City. The petitioner has, the General Counsel for the petition has contended that as per the statement of accounts pertaining to the said bank account, a lien had been marked over an amount of rupees 20,000. Yet, the petition has been prevented from operating the bank account in respect of the amount lying in the said bank account over and above rupees 20,000.
It's 22,000, Lordship.
Lordship,
22,000.
20,000 is the cyber complaint, and there are two 1,000. It's, I think, regulatory
No,
complaint.
it is your petitioner's statement.
It's 20,000.
Post of para. Notice was issued to the respondent authorities, including the respondent number 2 and 3. On 11/3/2026. Post of para. Mr. Sinha, learned counsel appearing for the respondent number 2 and 3, has referred to the statements and averments made in the affidavit in opposition filed on behalf of the said respondents. Apart from raising the issue of maintainability of the petition, Mr. Sinha has submitted that the respondent bank authorities had received a debit freeze instruction on 25/6/2025 through the Cyber Crime Reporting Portal, page 34 of paragraph 10 of the wide acknowledgement number within bracket NCRP stroke CFC FRMS, being a citizen financial cyber frauds reporting and management system, CFC FRMS, operated through the National Crime Reporting Portal, within NCRP, or the Ministry of Home Affairs, Government of India. Post of Para. In the affidavit of opposition, it is further mentioned that the instruction, the debit freeze instructions was amended from the Cyber Crime Police Station, Coimbatore City, Tamil Nadu, in connection with CSR number dated 25/6/2025, directing immediate lien marking and debit freeze of the bank account of the petitioner. And it is upon receipt of such instruction through the CFC FRMS stroke NCRP platform, which is monitored by the respondent bank on a real-time basis for regulatory and law enforcement compliance. The debit freeze stroke lien marking instruction was implemented. It is from the affidavit of opposition, it has emerged that the respondent bank authorities, in the responding industry bank authorities, had kept the bank account of the petitioner in debit freeze condition in view of suspicious transactions in relating to three amounts: rupees 20,000, rupees 1,000, and rupees 1,000 respectively. That is, rupees 22,000 in total. In response, the counsel for the petition has submitted that as the instruction is received only to an extent of rupees 22,000, there is no bar. The action on the part of the respondent industry bank authorities to keep the action on the part of the respondent of industry bank authorities to keep the entire bank account of the petitioner in debit freeze condition is unauthorized. Para. Yes, anything is ever in the affidavit? Further?
No, so that is only with regard to the 20,000 and the 2,000 extra.
Mr. Sinha has submitted that in the absence of any revocation or clearance from the concerned authorities, the respondent industry bank authorities has no legal authority or discretion to lift the freeze stroke restriction imposed upon the bank account of the petitioner. Para. wrong. I have not my issue 7, 8, 9, 10. Amount to change for you, Okay. Keeping a lien on 22,000.
Might please your lordship. In this case, my lord, kindly see the last order, my lord, 8/6/2026. Here affidavit is required, 1, 2, and 4. So matter is, my lord, petitioner is a victim of cyber crime, my lord, not a willing participation, my lord. Petitioner had received an SMS, my lord. After receiving, alleging violating the rules of traffic rules, my lord. Link was given, paid ₹500.
Debit
card, my lord.
You maintain account where?
ICICI Bank, my lord.
Whether they have filed any? Yes. Mr.
Yes, your lordship, we are ready, but we will file it today or tomorrow.
We have also received the affidavit.
You are from
I'm for respondent one.
one. Five and six.
Already filed, my.
Already filed, your lord.
Okay. Mr. B.K. Sharma, learned counsel for the petition. Come on, Mr. P. Hazarika, learned counsel for the respondent number 1. Come on, Mr. M. Sharma, learned counsel for the respondent number 2. And Ms. M. Gorman, learned junior government advocate for the respondent 5 and 6. Heard. So both Mr. Sharma, both Mr. Hazarika and Mr. Sharma, I have sought for how much time?
By tomorrow we'll file.
Tomorrow.
Okay, I have sought for 1 week time for filing the counter affidavit on behalf of the respondent number 1 and the respondent number 2 respectively. The prayer made above is accepted. List the case on
31st July, 3107.
Obliged.
Item 37.
In this case, Lordship, we have received the instructions, but the instruction is not complete. I have to get
how much by the time?
4 weeks, Lordship.
Okay. R. Ali, petitioner, N. Bordeloy, Revenue 1, H. Sharma, 2 and 3, NHCI are present. So Mrs. Sharma, the additional senior government advocate has submitted that he has not received the complete instruction and has thus sought for further 4 weeks time to complete his instruction and to file the counter affidavit on behalf of the respondent number 2 and 3. The prayer is allowed. List the case on students.
17th August, 1708. Item 38.
The instructions.
Your lordship, in this case, we have received instructions today only. So.
How much time?
Yes, your lordship, 1 week time maybe. 1 week time maybe.
Can sure. So this. Heard Mr. M. Ali, learned counsel for the petition, and Mr. M. Sharma, learned counsel for all the respondents. Mr. Sharma has submitted that he has received the necessary instruction to file the counter affidavit and has the sought for further 1 week time to file the counter affidavit. So the prayer is allowed. The counter affidavit shall address the aspects highlighted in the order dated 23/6/2026. Your name is not reflected. The name of Mr. M. Sharma and counsel for the respondents is to be reflected in the respondent side the comments.
31st July, 3107. Timing matter, item 27.
RDB exit. RDB is not there. She is not present today.
Lovely Devi.
R.
Devi, I have not
CGC,
seen.
CGC.
I have not seen. I have not seen.
In this case, my lord, although affidavit is required to file, my lord, on last date, my lord.
Yes, I have.
But she is present, my lord, because one of, could go. Huh? She is at court 10, my lord.
Record absence, heard Mr. Once more opportunity, 1 week. Heard Mr. M.A.I. Hussain, learned counsel for the petitioner. Panchayat, Miss Miss P. Thapa, learned counsel on behalf of Mr. S. Doctor, learned standing counsel, Panchayat and Rural Development Department for the response number 1, 2, 5, 6, and 7. And Mr. A.R. Tobildar, learned counsel on behalf of Mr. R. Devi, Miss R. Devi. Or you are there also?
Yes, I am also.
You are there?
Yes.
Your name is there?
Yes.
Okay, Mr. A.R. Tobildar, learned counsel for
For
response number 8.
Okay.
So, do you intend to file any counter affidavit?
Yes, Lordship, it's required.
So, how much time?
2 weeks should be, because we could not contact the client directly. Lordship.
Okay, Mr. Tobildar, learned counsel for the response number 8 has sought for further
2 weeks time.
2 weeks time
Yes.
to file the counter affidavit.
Lordship.
Post of the price allowed, release the case on soils. I
7th
think
August.
3 weeks of data, 3 weeks.
Three weeks.
If after filing of the counter affidavit by the respondent number 8, the petitioner wants to file any reply affidavit, the same shall be filed on or before the next date of listing.
17th August. Not 17th. 18th.
Your time is 2 weeks,
2 weeks. Yes.
not till 17 August.
No. Oblige that.
For orders, item 39.
May I refuse? Say against demolition by the Gauhati
No,
Metro.
today that has not come.
Yes, my lord, there is.
Service
provision for
report.
Appeal, my lord, that is earlier one similar matter, my lord, similar person appeared before us that was disposed of by additional court, my lord.
Yes, there is a
This
similar.
matter may be also disposed of.
Let them file an appeal before the district judge. There is a provision that statutory appeal is there. Lordship will dispose of similarly.
Which one?
This is, I think it is petition number 2591 of 25, my lord.
Against the same impugn order that the petition was also disposed.
One more was disposed of by this court.
This one, my lord.
No. Another one, the provision.
So 71, 73 you have to file an appeal.
That they few days back, just before vacation, you were there?
Another one, my lord.
6. This was disposed.
This was disposed.
A GMD appeal.
17.6, my lord. This is 17.6, it was disposed of. This
Some
more other matters were.
near medical or somewhere.
I also forgot, my lord.
Huh?
I also forgot, my lord.
You should not have forgotten.
My lord.
Heart. Right, this is same thing.
Same thing, my lord.
Huh?
Same building. This is same building.
Oh, same building.
Same building.
Okay, I'm dictating, you find out, right? Third, Mr. S. Soikia, learned counsel for the petition. Municipal administration, government, Ms. M. Bormon, learned junior government advocate Assam for the response number 1. Mr. S. Bora, learned standing counsel, Gauhati Metropolitan Development Authority, GMD, for the response number 2 and 3. Para. As per order dated 3/6/2026 of the Loajima Court, notice has been duly served upon the response number 4 and the response number 5. But despite service of notice, none has appeared for the response number 4 and 5. Full stop. Para. In this writ petition, it's stated under Article 226 of the Constitution. Come on. The petitioner has assailed an order. Here I got para number 16/5/2025. Assailed an order under number ECF number 517123/3 dated 27/1/2025.
27 total.
Passed by the respondent number, passed by the Chief Executive Officer, CMDA, within bracket, the respondent number 2, post stop.
I got that writ petition, my number also I got that, my lord. Writ
Number?
petition number 3459 of 2026.
Right? Para. The petitioner has projected that the impugned order, the order dated 27/1/2025, was served upon the builder stroke developer and the owner of the land where the alleged apartment building,
This is just a building, my lord, not.
the
it cannot be an
RCC building,
RCC building.
alleged RCC building has been constructed. Also, the petitioner has stated that he is a resident stroke owner of an apartment, comma, measuring 985.08 square feet, within bracket super built up area, bracket close, at the first floor of the said RCC ground plus 2-story building situated at a plot of land measuring 1 katha 10 lesas, comma, covered by DAG number 327 and KP patta number, periodic patta number 831, comma, at Revenue Village, Ulubari, Mauja, Ulubari, District, Kamrup Metro. Post stop. Para Mr. Soikia, both Mr. Soikia and Mr. Bora have submitted that another petition, comma, WBC number 2591, 2025, comma, involving similar issues and pertaining to the same building, comma, was preferred by that lady was apartment owner, was another resident stroke owner of an apartment like the present petitioner. So they have submitted that the said petition was disposed of by an order dated 17/6/2026. Having by a Korean bench, having regard to the fact that certain disputed questions of facts would fall for adjudication, and there is a provision for an appellate remedy under section 71.
It's 73, you have to file everything. It starts from 71. In under section 73, you have to
So
file.
my order was more detailed perhaps.
Not.
Under appellate remedy, under the ZMDA Act
1985.
1985. Declining to entertain the writ petition. Full stop. While not entertaining the writ petition, comma, the Korean bench has observed that non-entertainment of the writ petition would not preclude the petitioner therein from availing the remedy of appeal under the GMD Act 1985 before the appellate authority. So it was further observed that if the petitioner would file an appeal within a period of 30 days from the date from 17/6/2026, the same shall be decided by the appellate authority on merits without insisting upon the question of limitation. Where? Where is the Indian order?
Page 76, my lord.
Five copy.
Original order?
79.
9. It moved order to para 8. Para 9. Para 10. Para 11. Next para. The learned counsel part of petitioner has expressed that the petitioner intends to avail the statutory remedy of appeal under the CMD Act as the appellate authority has been vested with all the powers of a civil court for the purpose of taking evidence on oath or enforcing the attendance of witnesses, including the parties interested or any of them, and compelling the production of documents and material objection if considered necessary, apart from the power to condone any delay. It was petitioner's side. PT. Para 13. Para. As the if the it is observed that if the petitioner files an appeal within a period of 30 days from the date of the instant order, comma, the same shall be the appeal shall be entertained by the appellate authority without insisting upon the question of limitation, and thereafter, comma, shall proceed to decide the appeal on merits. Full stop. As the order dated (27/1/2025) speaks about demolition or sealing of the alleged unauthorized construction of the RCC building, and in the instant writ petition, comma, the said order dated in the instant writ petition, the order dated 27/1/2025 has been kept in abeyance as an interim measure by an order dated 16/5/2025. This court, in the interest of justice and for balance of equities, comma, observes that the respondent authorities in the GMD, respondent GMD authorities, shall not give effect to the order dated 27/1/2025 for a period of 1 month from today, so as to enable the petitioner to avail the appellate remedy, as otherwise, if any action is taken in terms of the order dated 27/1/2025 by the respondent GMD authorities within a period of 1 month, the appeal to be preferred by the petitioner would automatically be rendered infructuous. Therefore, this court directs that the interim order dated 16/5/2025, passed in the instant writ petition, shall continue to remain in operation for a period of 1 month from today. Post stop. In the event, the petitioner prefers an appeal before the appellate authority within a period of 1 month from today, comma, the appellate authority shall decide the appeal on its own merits in accordance with law. Full stop. If the petitioner as the appellant seeks any interim relief, comma, the appellate authority will be within, it will be within the discretion of the appellate authority to decide on the interim prayer also on its own merits and in accordance with law. This order disposes of the also we are not entertaining. We are relegating you to file the appeal. Right. But we did 1 month.
Item 40.
R. Sharma, learned counterpart of petitioner.
Everything is complete method may come up for admission, Lord.
Mr. Gugoi, you are for?
For the excise department, Lordship.
Mr. R. Gugoi, learned standing counsel excise department for respondent number 1, 2,
1, 2, and 4.
4, and Ms. M. Borman.
3.
Junior Government of Assam for the respondent number
3.
3. Prosto. As per order dated 1/6/2026 of the Lojima Court, service of notice upon the respondent number 5 is complete. Prosto. As all the respondents are duly served with notice, office to list the case after 2 weeks in the appropriate column, in the admission column. In the meantime, the respondents shall ensure that their respective counter affidavits are filed before the next date of this.
Interim order was there. That may continue.
The interim order, past the shall continue till the next.
Obliged, Lordship.
41.
In the case, Lordship, as per the last order, we have to take steps, Lordship, to the respondent number 6, who is a private respondent, Lordship. And Lordship, very unfortunately, we are just taking steps and steps.
Huh?
We are just taking steps and steps, but the respondent authority doesn't reply, Lordship. And Lordship, as per section 27 of the General Clause 1897, Lordship, if a notice is served to the respondent, Lordship,
13/7/2026 order says that no fresh step has been received by the section for issuance of notice upon the respondent number 6 till date.
no, Lordship, we take steps, Lordship.
Today is 14 or 15?
15, Lordship. We're just taking steps and steps, days after days, Lordship.
But
the
record does not
respondent-
reflect. You may have directly gone to the post office, posted there without routing through the registry.
Lordship, unofficially, we came to know that the respondent.
We are not unofficial, we are official.
He is a private respondent, he is refusing to accept the notice, Lordship.
We don't know. We go by the records reflected, no step.
Lordship, as per section 27 of General Clause 1897, Lordship, if a notice is served to the respondent to any specific address, whether the recipient is refused to accept the notice, it is legally presumed that the notice is served, Lordship.
General Clauses Act. It is rebuttable presumption or irrebuttable presumption? General Clauses Act of which year?
1897, Lordship.
So it says what?
It says if a notice is served by a registered post to a specific address, Lordship.
But it has to be proper and correct address.
Yes, Lordship.
Yes.
And we have
We don't know.
We have
That
steps.
fact is not available with the court.
Lordship, we take steps, Lordship, to the specific address, Lordship.
Yes, that may be wrong address. Where is the proof? What you are challenging?
Lordship, my challenge is that respondent number 6 who violate some rules.
Violate some rule.
Yes, Lordship.
Hmm.
Student number 6. Lordship, kindly come to the page number 8, Lordship, para 7, 4.
Para 4.
Yes, Lordship. Have a look on page number 8.
Para 4.
Yes, Lordship. The respondent number 6, that is Anwar Hussain, who offered his candidate for the
Respondent
post.
5.
No, Lordship, it's 6, Lordship.
But in our record, it is 5.
Lordship, it may be
Huh?
wrongly reflected.
Everywhere it is 5 only.
Lordship, it's a 6. Respondent number 6. You may look on the cost title, Lordship.
What about all these paragraphs? Respondent of 5. Everywhere only respondent of 5 only.
Lordship.
You are a contesting candidate, right?
Yes, Lordship.
You have been defeated.
Sorry.
You have been defeated.
Yes, Lordship.
And you
But
still
Lordship,
don't know.
the candidate Anwar Hussain, he has more than 2 children, Lordship.
You are Mr. Firdaus.
Yes, Lordship.
So on the earlier date, 17/6/2026, what has been recorded? What has been recorded? That Loazima Court has reported that the petitioner has not taken any steps for issuance of notice upon the respondent number 6, despite being afforded several opportunities for compliance. So it needs dismissal right now.
No, Lordship, we would take steps, Lordship.
Where is the proof, Mr. Counsel? For invoking section 27, you have to take steps.
Yes, Lordship.
And you are seeking disqualification of respondent number 6, who all throughout your writ petition has been mentioned as respondent number 5. Loazima Court has recorded wrongly. This is your submission. Your submission, you have taken repeated steps. And Loazima Court has said that petitioner has not taken any steps for issuance of notice, despite being afforded several opportunities for compliance. Mr. Sharma will send it to the civil court. Factual determination will be required. Disputed questions. Loazima Court says several opportunities, no steps. He is saying several opportunities, several steps, several times taken. We relegate it to civil court to decide this matter. Thereafter, we'll decide about
Lordship, kindly.
how much
possible-
years of practice you have put in, sir.
Lordship, it's been 3 years. Lordship, another chance, if possible.
So don't waste such time when after this court has recorded that accommodation has been sought for by Mr. Firdaus to take steps upon respondent number 6 within a week's time. After seeking time on the previous date to take steps, don't make such submission. Your submission is contemptuous. Is it not?
Yes.
Better be careful before making submission.
Yes.
On the earlier date, you have prayed for time to take steps. Now you are saying a different music, tune. That is why I put on record that despite several opportunities, you have not taken steps. Shall I close?
Yes, Lordship.
Dismissing the writ petition?
No, Lordship, can you give another chance?
Mr. Firdaus, I'll record. Right. Learned counsel for the petitioner is present. Mr. Full of mistakes, the writ petition.
Respondent number 5 everywhere.
No, everywhere, no. Typing mistake, everything. Mr. H. Sharma, learned additional senior government advocate for the respondent number 2. Ms. P. Thapa, learned counsel on behalf of Mr. S. Dotto, learned standing counsel, Panchayat and Rural Development Department for the respondent number 3, 4, and 5. And Ms. P. Kayastho, learned counsel on behalf of Mr. R. Dubey, learned standing counsel, Assam State Election Commission for the respondent number 1 are present. Posting this court on 17/6/2026 has passed the following order. Beginning, mark petition. Para today, Mr. Fidos, learned counsel for the petition, has submitted that a presumption under Section 27 of the General Clauses Act 1897 is to be drawn as regards service of notice upon the respondent number 6, which respondent has been mentioned as respondent number 5 throughout in the repetition. There has been no application. There is no application for amendments of such mistakes committed in the repetition, occurred in the repetition. Be that as it may, Mr. Fidos has again sought for 1 week's time to file, to take steps upon the respondent number 6 in compliance of the order upon respondent number 6 by the petitioner is permitted to take fresh steps for service of notice on the respondent number 6 by speed post within a week's time, less the case after 6 weeks.
Yeah, please, Lordship. Lordship, as per order dated Lordship 28/2025, I have taken steps and Lordship.
All right, Mr.
A. Dr. Lordship.
A. Dr. Learned counsel for the petition. Corporation Department.
Yes.
Any department is there? Corporation Department.
I have amended.
Huh?
I have amended 5 parts.
Nobody is there. Mr. H. Sharma, senior government advocate, Assam for the respondent number 2 and 4 is present. As per order dated 10/6/2026 of the Lower Jima Court, service of notice upon the respondent number 3 is complete. The learned counsel for the respondent number 1 is found absent to the uncalled. As all the respondents are duly served with notice, says, let the case be listed after 2 weeks in the admission. The respondents shall ensure that their respective counterclaims are filed in the meantime.
There is an interim order, Lordship.
The interim order, if it passed, it shall continue till the latest.
If you please, Lordship.
File over there.
Wait, the Lordship steps upon respondent number 4 and 5 complete.
4?
4 and 5 complete, Lordship.
4 complete.
Meter may come upon admission column.
No, where is the report? That 5 has been served?
Or reporting in office authorized.
Then?
I'm appearing for the.
Oh, you are appearing? Good. You are appearing for?
4 and 5.
4 and 5. Okay. All right, Mr. U.S. Bora, learned counsel for the petitioner. And Mr. Revenue available. Aforesaid revenue 1. Mr. H. Sharma,
2 and 3.
learned additional senior government advocate, Assam for the respondent number 2 and 3. Mr. M. Islam, learned counsel, has submitted that he has instruction to appear on behalf of the respondent number 4 and the respondent number 5. You have filed Ukaranama?
Well, only 5, but it's starting.
So he has submitted that he has already filed Ukaranama for the respondent number 5. And he will be filing the Ukaranama for the respondent number 4 within a week's time. Okay? So as all the respondents are represented, this is the case in the admission column on so and so.
Lordship, interim is there. status quo.
Okay. List the case in admission column after 3 weeks or later video. The respondents are to ensure that their counter affidavits are filed in the meantime. The interim order past address will continue till the next request. 3 weeks time is granted.
4 weeks.
4 weeks. 4 weeks. So 4 weeks is
19th August.
19 August.
Early of next.
Item number 44.
Yes.
Respondent number 1 and 2 have to.
1 and 2.
Lordship, this matter pertains to Lordship, satisfaction of an award passed by the Motorists and Claims Tribunal, Lordship. Now, what has happened is the offending vehicle is from Bhutan. The award is passed here. Now, how to get that executed? So, therefore, Lordship, on the previous occasion, the court had directed me to take instructions from the Ministry of External Affairs and another, like how we are going to satisfy it. Pursuant to that, Lordship, I have placed some materials on the previous occasion. My friend relies upon a tripartite agreement between India, Bhutan, and Bangladesh, where so far as road transport is concerned. But I have found out that this agreement is not ratified by Bhutan, so it will not be applicable to Bhutan. But however, Lordship, the Ministry of External Affairs has taken it up with the government of Bhutan. So far as satisfaction of the award is concerned, in the month of May, last part of May, I do not have the updated instructions right now, Lordship. If your Lordship will allow me some time, I will get the updated instructions, or as Lordship can proceed.
I had a scare.
Lordship.
I myself drove to Bhutan in my own vehicle. And at the border, it was said, and throughout 7 days I drove. Me and my family also was there. And without any mishap, again I entered India. Thereafter I came to know, during that time, my vehicle's insurance policy was not operative. So my insurance policy was valid only in India, not in Bhutan.
That is all.
You ought to have taken another insurance policy
for that time
for Bhutan.
Lordship.
And if something happens, then there you will be in jail. Because the death, compensation for death will be astronomical.
But the position is
not
just
unlike
opposite.
peanuts.
Position is opposite here. The accident is here and they go.
Right?
Yes.
So their insurance policy was not operative.
Lordship. Yes.
Likewise, their insurance policy was operative only in Bhutan. So that man had to pay from his own pocket. Insurance company, even if there is insurance policy, they will deny. Mr. Sharma will deny. You represent the insurance company, right? Bank, otherwise insurance also? Insurance also.
No.
So they will deny. Entire burden will come on the owner. So what Bhutan government has to do? The story is for that. What Bhutan government has to do, it is the Bhutan is national. If it is a private vehicle. If it is a government vehicle, yes, Bhutan government has to do something out of respect or commitment, right? But what private person will do, that may be an eventuality. We cannot issue a warrant to bring that person. For that, letter rogatory has to be issued, criminal case has to be brought to a logical conclusion. All these are there. Otherwise, no letter rogatory.
Yes, my lord.
All these are there. I don't know what will be the fate of this case.
There are similar other two matters, I guess. One, I remember the name.
No, I was still, I was having a scare after that.
In fact, there is a provision that if a foreign vehicle comes in, there has to be a registration at the gate, which the India
No, my vehicle was also registered, but nobody told me that you should take a
insurance.
insurance. I was advised to take new mobile number and took mobile number, but I heard Mr. M. Soikia learning transport application and Mr. R.K. Devchuri learning senior counsel and deputy solicitor general of India. So the response number one and two. Post of Mr. Devchuri has submitted that though he has received instructions partially, further instructions are awaited. And he has submitted that the government of India has pursued the matter with the government of Bhutan. And the matter is being pursued by the government of India with the government of Bhutan. And it is expected that further instructions should be received within 6 weeks' time. He has sought for listing of the matter after 6 weeks in order to apprise this court whether further instructions are received or not, and if received, to what extent. Release the case. As sought for by Mr. Devchuri and agreed to by Mr. Soikia, release the case on Swains after 6 weeks.
2nd September.
Also,
Item 45.
I is for what?
Yes, Lordship, for implement of Revenue Secretary as respondent number 7. Lordship may kindly check the order dated 19/6/2026 in the read petition.
Heard, Mr.
Lordship, I am NJ Daimari on behalf of Mr. P.K. Das.
Your good name, please.
NJ Daimari. NJ Daimari.
NJ Daimari Learned Counsel. Working for the applicant.
I am appearing in IA, Lordship.
Who is for Power Grid?
Lordship, I am.
Mr. R.K. Talukdar, Learned Standing Counsel. Power Grid Corporation for the opposite party number 1, 2 and 3. Mr. N. Das, Junior Government Advocate, Assam, for the respondent number opposite party number 4 and 5. And Mr.
BC Musahari.
B.C. Musahari, Learned Standing Counsel, BTC, for the opposite party number 6. Well, the petitioner, the applicant, as the petitioners. The applicant, how many? A single?
No, Lordship, 110.
Huh?
100 or single applicant in the I.
That is not the way. The applicant. And anyway, we'll ignore that. The applicants, that's read petitions. The applicants as read petitions have preferred the accompanying read petition. WPC number 2841 2022. Challenging actions on the part of the respondent, OP, opposite party number 1, 2 and 3, in erecting towers and installation of electricity lines over the lands of the petitioner. Post. Para. The instant application is filed seeking implement of the following authority. 7. The Revenue Secretary, Overland Territorial Council within bracket PTC, PTC Headquarters, Kokrajhar, District Kokrajhar, Assam, as party respondent number 7 in the accompanying writ petition as poster. Where it is averred that the presence of the proposed party respondent number 7 is necessary for adjudication of the issues raised and involved in the accompanying writ petition. Para, the learned counsel for appearing for the opposite parties have submitted that they have no objection if the instant application.
And then lordship permission, revenue secretary, instead of revenue secretary, secretary, land and revenue, lordship. Lordship, revenue secretary, this is maybe instead of revenue secretary, secretary, land and revenue, lordship.
Okay, secretary, land and revenue. Huh? It is, they have no objection if
There is
the
no
instant
such-
application is allowed. Post of having regard to the issues raised and involved in the accompanying writ petition. Comma, this court is of the considered view that the proposed presence of the proposed party respondent 7 is necessary. Is a necessary party respondent. Therefore, the instant application is allowed. So stop. Next.
Extra copy, lordship.
Oh, I have not yet issued,
Lordship.
Mr. Don't go 2 steps ahead.
Lordship.
Number likhi dibo. The learned counsel for the petitioners shall file an amended cost title in terms of so and so. I can likhi dibo. Within 3 working days from today after so and so correction. In a CIS and as well as so and so. Left first of office to list. Registered list the case. After completion of the above formalities and on a date after a week after completion of the above formalities.
Mass problem. Item 46.
If sir completed your lesson on the last occasion, your lordship was directed.
Yes, you appear.
Yes, your lordship, for respondent
And
number 2.
Mr. K. Decker, learned counsel for the petition. None has appeared for the respondent number 1 on call. So Mr. M. Sharma, learned counsel, has submitted that he has instruction to appear on behalf of the respondent number
2, your lordship.
Your file ukal nama
No, your lordship, will file it.
and has sought for 1 week time to file the ukalatnama. He has also submitted, Mr. Sharma has also submitted that he can never to obtain necessary instruction in the matter within a week's time.
Yes.
Release the case on so in the appropriate forum.
Yes.
10th August, 10/08. 47.
Same.
Same.
Same, your lordship.
Same.
And also respondent number 2, I am appearing.
Okay, same 47.
Item 48.
Hubli Municipal.
Private site appeared here.
And APR for since 7, right?
You have appeared
Private respondent.
and this is for 6 and 7 only.
6 and 7. Private respondent.
Notice has been issued. Just a minute. So as Islam 6 and 7, but 4 not yet.
Both municipal board.
Oh.
I think they.
Oh, how can he? You have been directed to take steps. Have you taken steps?
Dusty steps.
No dusty.
And other.
You are not answering phone call.
On Monday, your lordship, out of station, your lordship. I've
No, no.
taken other
The
system.
issuance of notice have not been collected by the petitioner. When contacted by phone call was not answered. The same was also communicated through a text message. However, no response has been received from the petitioner as of yet. This is your conduct
On 13.
regarding dusty service.
It was. Order
It
passed
is in black and white.
Yes, lordship. Order was passed in vacation court, your lordship, on Monday. I was out of station. I have
We'll
taken
await
also
for,
extensive-
we'll await for service of notice. It is when? Oh, only on 2/7. Some interim order is there. And Mr. A.R. Karim, petitioner. And Mr. N. Das, learned junior government advocate for the respond number 1, 2, 3, and 5. 5. Not 5. I'm sorry.
On the other day,
J.K. Goswami,
my colleague appeared for 5, but
5 also.
yes, my lord. But,
Huh?
5,
If 5 is there, then 4 is also there. How can you discriminate? Oh,
executive
4 is chairman.
chairman, my lord. Chairman. An
Chairman.
executive officer is a government.
So Mr. S. Islam has submitted that he has instruction to appear on behalf of the respondent number 6 and 7. You have filed number?
Sometimes I have received.
And he will be filing the Ukanama on behalf of the state respondent within a week's time. Post up. Peruse the office note dated 13/7/2026. Post up. Await for the service report in respect of the respondent number 4. Place the case on switch.
7th August, 2008.
The interim order
Shall continue, may thanks.
shall continue till the next one.